for incubation and extension of interim order, my lord.
It's subsisting or interim order is still subsisting or it has
Has
ended?
been expired, my lord.
Then you take out an application.
My lord, we have filed, can applicate.
Give it.
Lordship, may I be permitted to mention, Lordship, new motion inclusion in the list. Lordship, item number 154 and 155, I'm praying for upgradation. Mr.
I'm not allowing.
Siddhartha Banerjee, learned senior counsel is coming.
Upgradation I'm not allowing. I have not allowed anybody. If time permits, if both parties are there, time permits, I'll take.
Lordship, he
Because
has
every
come
matter-
today. Lordship, thank you.
No question of upgradation.
Your Lordship, may I be permitted to mention, Your Lordship? We want to not press one petition. Actually,
Non-prosecution. Bring a letter.
today is in the list, this matter.
You have brought the letter.
No,
I
I,
declined then.
okay, I'll just bring, grateful, Your Lordship.
সাড়ে 10টা বাজে তো না ওটা স্লো আছে ওটা ঠিক করে দিন হ্যাঁ আর ওটা ঠিক করে দেবেন কল করুন নট টুডে আজকে তো আবার রেজলিউশন আছে না
Lordship, item number 2 is for correction, Lordship, by small correction.
Yes.
In place of state, Lordship, there will be respondent in the order. Because I am representing the central government, Union of India.
Yes, that is the only correction.
And at page 5, last paragraph, operating 7 different forms, it will be 8.
Page 5.
Page 3, Lordship.
Page 3.
Last para.
7. 7 will be 8.
8, Lordship.
This 7, 8.
Actually, this petitioner is operating 8 forms. So that's why, but it is print, most probably my mistake, maybe.
Let
So
it be
8.
You will bring the right fact on affidavit. How does
Okay,
it?
Lordship. No,
I'm
no.
changing that.
Lordship.
Yes. This matter has been mentioned for correction. Full stop. Appear for the Union of India and the CGST authorities.
Yes, Lordship.
Meaning?
No, here, no, Union of India is not the party, only CGST.
No, Union of India is respondent number 1.
Oh, then Union of India and all. Respondent, all respondent.
The
Lordship.
Union of India and the CGST
Others.
authority. Within brackets, all the respondents. Full stop. State of West Bengal is not a party. And as such, the recording that Mr. Agarwal appeared for within inverted commas for the state, for within inverted commas for the state is incorrect. Full stop. Let the expression for the state, we inverted commas, mentioned beneath the name of Mr. Dilip Kumar Agarwal and Mr. Biswaraj Agarwal be deleted, and the expression within inverted commas for the respondents be inserted.
Yes,
for the
DPL.
respondent.
Yes, Lords. DPL.
Let the aforesaid correction be incorporated in the order dated July 3, 2025. Full stop. The other portion of the order shall remain unchanged.
Deeply obliged.
For the statement.
Today there is no adverse order resolution.
As your lordship.
Not today. Not today. Not today.
আজকে কিছু হবে হবে না আজকে।
You will do it. You will do the matter today.
Yes, my lord.
Very well. Passed over.
Grateful, my lord.
Number 5.
I represent state.
Not today.
6.
Lordship, in item number 6.
The petition, my lords.
For the finance company.
This is a matter which is to be heard analogously. Two matters are here in this matter. That is similar matters. These are similar matters which has to be heard earlier is WPA number 2381 of 24. That is Sukumar Sharma versus the state. That
It is not
matter-
appearing in the
No, this is not appearing in the list.
Very well. What is the matter about?
Now, the matter pertains to blacklisting of the vehicle. Our contention before my lordship would be 3.
Was
because
this
is the
matter
third round
heard
of
earlier?
litigation. My lordship,
Was this matter heard
Yes,
earlier?
yes, it was heard.
it was heard earlier.
Yes, Lordship.
देखिए दादा.
The subject, my lords, unless they suggest otherwise, my lords, this can be placed along with 2381 of 2024 tomorrow to be mentioned. But otherwise, my lords, this is a matter relating to blacklisting. What happened, my lords, was that the petitioner herein is an auction purchaser of a vehicle. The vehicle was not transferred in the name of the petitioner. In the first round of litigation, my lords, the court was surprised as to how the vehicle could not be transferred despite the fact that the petitioner is the auction purchaser. Thereafter, my lord, direction were passed to transfer the vehicle. Then, my lords, there was a 34 certificate that was to be issued by the financier. The financier didn't issue it. So, my lords, this required some hearing, my lords. Let it be placed, my lords, at the request of the learned counsel for the respondent. Let it be placed tomorrow along with 2381 of 2024,
Yes.
which is the lead matter.
Both the matters are required to be heard analogously, Lordship. 2381.
Number 4.
Have it before the next circuit, because tomorrow will be a hearing day. Then second half. To be mentioned, what can be done? Can it be heard as to be mentioned?
It can be heard and finished off, my lords.
Mentioned, it can't be. We'll have to appear either as motion.
Then let it retain its place, my lords, in the motion, in the new motion.
Will it not require
Analogously,
fact
বলেছি
findings?
কোথাও?
Not required.
কেননা ওইটাতে
Not required.
আমাদের instruction আছে।
It can be disposed of, my lords.
Give me an idea of the matter.
Yes, my lords. What I was saying was that the petitioner here is an auction purchaser. He purchased the vehicle in an auction after the vehicle was declared NPA and defaulted upon through the respondent number 4, the Cholamandalam Insurance Company.
Right.
Initially, what happened? The erstwhile owner of the vehicle, he filed a complaint before the RTO. Based upon his complaint, the RTO blacklisted the vehicle. Therefore, the transfer could not be done. We came before the read court. We requested and besieged the read court, saying that the RTO does not have an authority to blacklist the vehicle. That too, based upon a complaint of a willful defaulter. That was decided in round 1. Thereafter, my lords, there was a round. It went up to the division bench, then again came back to the single bench. Then there was a round 2 of the litigation. In the round 2 of the litigation, the only issue was that because the financier hasn't issued a 34 certificate or so, therefore the vehicle could not be transferred. That was also disposed of. Now, my lords, this is the round 3. The only thing that needs to be done, my lords, is that the finance company would issue a 34 certificate and the vehicle would be transferred in the name of the right.
Finance company.
My lords, Mr. Paul is appearing for the.
And for the finance company.
Yeah, Mr. Paul, what is the problem? If you have received the money,
My lord, we have provided all documents, whatever documents we had. We have given all assistance, my lord.
he says he has given all assistance.
So based upon his assistance, the RTO would be directed to transfer the vehicle to me.
No, but.
State is the RTO.
Lordship, in this matter, I have got the. Relevant portions are paragraph number 4.
দেখে দেখে কি বলছে যাই না কি চাইছে দেখি তো
শুধু বলবে
4 নম্বরে কি চাইছে
4 স্টার্ট হলো, আমার কাছে তো কিছু চাইছি না।
ফর্ম 36 ফর্ম 36 দিয়েছিস তুই হ্যাঁ ওটা 36 চাচ্ছে
It says now the petitioner may inform the financer
Yes.
to apply in form 36.
that has been done but whether they have given the form 36 or not হ্যাঁ করেছে
So Mr. Paul,
অনেকবার করেছে জোর করে একবার লেখাইছে যে আগেটা গুম হয়ে গেছে তারপরে অ্যাপ্লাই করা হয়েছে
Mr. Paul,
My lord.
form 36.
My lord, can he take it up tomorrow?
let him come up with a copy of the form 36 tomorrow. It can be disposed of, as simple as that.
Form 36 লাগবে তো?
হ্যাঁ
This matter along with
কালকে নিয়ে আসবি ফর্ম 34 36
WPA, give the number
2381 of 2024
2381 of 2024.
2024 within brackets name.
Sukumar Sharma
versus the state office and others.
Write it on a
দুটোতেই
piece of
চাই,
paper.
দুটোতেই চাই।
Right,
না,
right.
form 36 চাই।
Correct.
দুটোতেই।
হ্যাঁ, হ্যাঁ,
yes
একদম। একই।
Form 36 শর্মা।
Sharma আছে
Relevant portion.
কালকে এটা দিয়ে
এটা
দেবে।
transfer of ownership এর
to be mentioned tomorrow lords, it can be disposed of in 10 minutes.
At the same, in the same.
Lordship, the report filed by the state may kindly be taken on record.
They will bring the form 36 and it will be disposed of.
ভালো। নাম দিয়েছো?
Generally কি হয় আমি যদি জানি তুমি না তাহলে আমি এমনি ট্রান্সফার করছি এই ব্যাপারে আগে বলছে না আমি যদি করব না আগে ইসলাম নামে যাবে তারপরে আমার নামে স্পেশাল নিয়ম আগে তোর নামে ট্রান্সফার হবে তারপরে আমার নামে
না এইটা হচ্ছে স্যার তাই বলে লিখে দিল
ডিপ্লব
Lordships, I beg to appear virtually in 217 Lordships.
Lordship,
Lordship,
Lordship, not today, Lordship, because this is the report and due to
Lordship,
strike,
Lordship.
I have struck down. So-
Lordship, this is the tendency of the other side. Before I start saying anything, they always take not today. Lordship,
No, no,
kindly
no,
give me 2 minutes
no,
to
no.
eat. Lordship,
No, no,
kindly, it is my matter, Lordship, kindly allow me 2 minutes to submit.
I regards Mr. Kanoria ji because I am always be there in the court. Because I never be absent. Because today my vehicle was struck by the picketing, so that's why I'm praying.
Lordships, I am, my only
My lord,
submission.
same thing is also for me. I am not in a position to appear physically. Kindly fix it tomorrow or day after tomorrow.
Yes, Mr. Kanodia, what is your problem?
Lordship, I don't have any problem. The only issue is this batch matters relates to refund rejections. The same officer in case of 11 SSCs has passed same copy paste orders rejecting refund only on the ground that some extraneous document has to be produced by us which is not to be produced. So on the last occasion on 10th of April, Justice Hridnamay Bhattacharya took up this matter and because of the seriousness of the matter, the state was directed to bring a report within 2 weeks. Till that time, Lordship, we are now 4 months has passed now. More than 3 months. They have not brought the records, they have not brought the report, and I am being penalized for no fault of mine. I have exported the goods, I have all my documents which is with the officer. The officer says in his rejection order that you bring a Bhutan custom declaration, which is to be filed by the importer. There is no requirement under GST law for me to produce. I have produced my EGM copy of export. I have produced transport documents. There is e-way bill. There is no dispute. He says in his order that, okay, because there is a fraud going on in this sector, so therefore you may also be involved in fraud. I will reject. Lordship, I am being penalized because, Lordship, I am a trader today. Kindly appreciate this point. I am a trader. I am purchasing, I am exporting. If I don't get my refund, under exports are 0 rated, then my whole working capital is stuck. I'm not able to do any business, Lordships.
Very well, but if there is a direction to file report, that report must come on record. If they are seeking.
Lordship, it was 2 weeks time, Lordship.
Very
10th of
well,
May.
those, Mr. Kanodia, we all know time.
Lordship, after that report, today is the fixed matter.
No,
So
Lordship, it is not
unfortunately-
fixed matter, Lordship. We mentioned
No.
it before various benches.
No,
Because
no, never.
Lordship, I can produce the mentioning slips also. I have those.
No,
If I
you
appear
have
before your
mentioned, but
Lordship.
we have not taken any time. You have mentioned, maybe.
Lordship, may kindly keep
Taken-
it tomorrow, Lordship, in that case. Or Friday, any day convenient, your Lordships.
Friday and tomorrow may not be possible. And in any case, it will not appear as a new motion. It can't be a new motion where reports have been directed to be filed. It can't
Lordship,
be.
it is not a case of hearing. It is not a case of hearing at all,
No,
Lordship.
it is in fact a case of hearing because I have seen the order. File Tatin. I have seen the order. It says
Lordships.
that there is no scope for passing any interim order and therefore reports have been called for. So therefore,
Yes,
there was no such urgency to treat it as a new motion.
Lordship, it is not hearing. I would again beg to submit, Lordship, it is not a case of hearing. It's a case of motion because your report was called because the matter revolves on
Maybe a
refund.
case of motion, but definitely not new motion.
Lordship, there is a provision.
New motions are those motions which have been specifically kept for further consideration in a short span of 1 or 2 days. Not after 2 weeks directing parties to file reports in the form of affidavit.
Lordship, I have not been directed anything. That is my
You may
predicament.
not
Had
be
I been
directed, but
directed-
they have been
had I
directed to file a report in the form of affidavit. So that affidavit must
Lordship,
be
then in
seen.
that case, if the other side never comes up with affidavit, I will be sitting tight. They will be sitting tight on that. 3 months, your Lordship, appreciate that 3 months have passed. There is no report today also.
No, tomorrow we have a report.
Lordship, if they have a report, kindly take it subject to your Lordship convenience.
I prima facie, Lordship.
That is what he was saying. I do not know why you are getting so hyper, Mr. Kanodia. I have never seen you that way. There is no
Lordships.
reason for you to be so hyper in this case.
Lordship, I am not being hyper because
You
before
are,
I submit.
you are
Lordships,
being hyper. It
I
is
like to-
very evident.
Lordships, I would like to apologize, but still I don't find that I am hyper because before
Your
I
apology
submit,
is not required, but
before I could have submitted my 2 learned seniors, they have started submitting before your Lordships. So
No,
there
otherwise
is
it
nothing
will
for
be
me to
wastage
submit.
of
Lordship.
time of the court.
that does not give you a
Mr.
reason to
Kanodia.
get hyper, Mr. Kanodia.
Lordship, I beg to apologize in that case.
Has
Your
it been
Lordship
your
feels
case that in your years of practice you have never sought for time?
I have not, Lordships. I
I
have
have
not.
seen you. I have seen you, Mr. Kanodia. So let us not be so truthful and let us not
Lordship,
be so modest.
to the best extent where I can assist this honorable
Best
court, I can.
extent is something else. You have never sought for time is something else. So let us not be that modest. If somebody is in difficulty someday, merely because somebody seeks time, that does not give you a right to get hyper all on a sudden.
Lordships, that is your Lordship's outlook, Lordships. Lordship may kindly then dispose of, postpone the matter, Lordship. No problem. No problem with that.
Learned advocate appearing for the state respondents.
Lordship, I am not able to hear your Lordship, sir.
Not the state, Lordship, CGST.
CGST.
To file the report in the form of affidavit in terms of the order dated April 10, 2025, full stop. List this matter tomorrow under the heading motion.
Much obliged, Lordship. Grateful to your Lordship.
All these matters.
Grateful to your Lordship.
Your Lordship, in this batch, I am for 6 seated petition.
Give your names, please give your names.
Grateful. Myself, Ratan Bonik, for yes, I'm giving my name.
I appear for the petition. Mr. Ratan Banik is there in the
Yes,
opposite side. My lords, this is a service tax matter. And there is a delay, my lords. From paragraphs number 6 to 12, my lords, of the writ petition, I have explained the delay, my lords. My challenge is on 2 counts, my lords. I am challenging the adjudication order as well as the show cause notice. Yes. My lords, my challenge is on two counts. Firstly, my lords, there is violation of natural justice. Why I say so? My lords, the show cause notice, in the show cause notice, my lords, I am a I am into government contracts. I make roads. Now this, I had got a contract from the West Bengal government for constructing road in some districts of West Bengal. Now in the show cause notice, now this period relates to up to June 2017. That is for the period of 3 months, because after June, the GST had come in. This is a service tax matter. So, my lords, this road construction was exempted under the service tax mega exemption notification. Now, the show cause notice was issued to me on the basis that as per your 26 AS form, you have received an amount of 61 lakh and odd rupees from this government company, and which you have not disclosed in your service tax return, neither have you taken any service tax registration. So therefore, there is evasion, and therefore we are invoking the extended period of limitation. In service tax, my lords, the usual time limit is 30 months. But if there is fraud, misful representation, there are 5 subheadings. Then with an intention to evade tax, if the both criteria are there, then they can invoke extended period. Now in the show cause, the allegation was with respect to 61 lakh. I submit them the work order, the payment bills and everything. In the final order, what they say is that because I did not submit them the complete documents, what happened, my lords, in the 26 AS form, the total amount I had received 4.5 crores from this government company. This, my lords, will see from the 26 AS form. Out of that, 61 lakh was received up to June 2017. So therefore, the show cause notice was that you explain the 61 lakh, how have you received? I give them a reply. I filed all the supporting documents. In the final order, they say that since you have not given me the complete documents of this 4.5 crore amount, and you have not given me the reconciliation documents, that is why they have dismissed mine. The assessing officer did not decide whether I am entitled to exemption. That was the basic issue which was needed to be decided by him. And this is on the counts of violation of natural justice, because he did not consider my documents. He went on that you have not given me the entire transaction, and you have not given me reconciliation statement of the pre-GST and post-GST payments, and that is why I do not accept this. So that was never put to me. That is my first point. And on the second point, my lords, I am also backed by a division bench judgment on this point by our court, where in a similar case, the matter was sent back to the adjudicating authority, but with a payment of 7.5% of the taxes amount. I should be candid because I cannot get away with that. Second point, my lords, on the point of limitation. Since this is a extended period of limitation they have invoked, my lords, and this is merely on the basis, they say, on the basis of 26 AS statement, which they have received from income tax, my lord knows well. Now, my lords, my point is on the similar facts and circumstances, since, my lords, this 26 AS, my lord knows, is a public document. It is not the case that I have suppressed something. I have been regularly assessed in income tax. I have paid taxes. I have filed my returns. Audited books are there. Only for the service tax, my lord, since I was not exempted, I did not take registration. And, my lords, there's a long line of judgment from Supreme Court, my lords, where they say that merely not disclosing something will not suffice. They have to show some positive act on my part. There has to be an intention to evade taxes. So my case, my lords, on the limitation point also, I am covered by a coordinate bench judgment by Justice Rajabasu Chaudhary, where he had admitted a writ petition which was filed belatedly on the point of limitation. There also the assessee was put to task. He was asked to deposit 5% of the tax amount. This is my submission, my lords. If my lords want, I will show you the order. My lords will come to page number 22 to 25, the show cause notice. My lords will see the allegation in the show cause notice. 22 to 25.
Yes.
5 and 6 is are the main allegation. 4, they say that I've received 61 lakh from this Westin Housing Saxby Farmer Limited, which is a government of West Bengal company.
Yes.
Then my reply, my lords, will find at page number 26 to 42 is my reply. 26, 27 is the short reply. Apart from that is the documents which I had submitted.
Yes.
Then my lords will come to the order which was passed in my case. Then a hearing notice was given to me. I appeared. I asked for extra time, but the second notice was never given to me. And this order was passed, my lords. Page number 43 onwards is the order. Operative part will start at page number 47. The discussion and findings. Para 4.1 onwards.
Yes.
4.7, my lords, they have decided, my lords will see, where they say, para page number 49, 4.7, if I may please. These documents, my lords, were never asked from me.
But it says that you had said that you will supply certain documents.
Yes, my lords, I'll see. My lords, kindly take page 4.4 first. What they say. 4.4.
Yes.
It is evident that out of total 4.76 crores, the noticee had received 61 lakhs during the period 17-18 from service. However, noticee in the defense reply provided work order dated 1/7/2016 of 1 crore 93 lakhs, 1 crore 93 lakhs of bituminous in the district. So they say I have not submitted the entire documents, but my lords, kindly appreciate that after June 2017, there was no service tax, this thing. I was not obliged, my lords, to submit them documents after that because they had not even asked me for that document. I gave them the document against which I received payment. I had received payment against this work order. I gave them that. Now they say that on the 4.7 that you have not submitted me the complete documents without answering the point whether I am entitled to exemption or not. Because that was the issue which needed to be decided by, my lords, by the authority. That is my case, my lords. That is why I say that it is violation of natural justice. Because if they wanted the entire document, they could have told me first. That was never
No,
put
but
to me.
was it not your duty also to produce it even without him asking for it?
Maybe, my lords, maybe. But, my lords, this is the facts, and I am placing it before you. And kindly see, my lords, what he says that I did not submit reconciliation pertaining to pre-GST period as well as GST liability. My lords, how does he have the jurisdiction to assess my liability of the GST period, my lords?
What is the point of limitation that you are taking?
The point of limitation, my lords, will see, I'll show you, my lords, section 73(1). 73(1) is the timeline which provides, my lords, 30 months time is there in normal cases. They are invoking the proviso, my lords.
They are invoking the proviso saying what you have suppressed.
Yes, they say that I have contravened the provisions of the act. I did not take registration. I did not file my returns with an intention to evade
What is
tax.
your answer to that? Why you did
My
not
lords,
take
I
that?
was an exempt, I was supplying exempt services. That is my case, and they did not consider that fact. That is my main contention here.
And why have you come late after September 2020?
My lords, kindly see paragraph number 6 to 12, my lords. Page number 6 of my writ petition, para 6 to 12, my lords. I have explained everything, my lords. There is a professional lapses also, my lords.
There is no provision for appeal.
There is provision for appeal. There is a provision for appeal.
Why didn't you not
Yes,
appeal?
yes.
My lords, that is why, my lords, I was assured by my authorized representative that he had taken steps in the matter. But later on, my lords, when the recovery notice came, I came to know from him in February, they issue me a recovery notice. First time after 16 months. Then, my lords, I approached him and he said that I have a complaint to the Bar Association. He had not filed any appeal. My lords, first decision from the taxman, my lords, this is, my lords, on the point of non-consideration of the reply. Here also, my lords, the exempt services were there. Operative part, my lords, are page number 4, para 4.
In this case, the petitioner therein had said that they would be submitting certain documents which they had submitted, and the authority had not taken that into
Yes, my lords, my case also, in my reply, my lords, I had submitted work order, payment certificate, and the completion certificate. Those documents, my lords, they did not consider. They simply said that you have not submitted the complete documents.
What is the period for you to approach the appellate authority?
My lords, it's 3 months, my lords. My lords, I'll just confirm.
It is 2 months, not 3 months, 2 months.
Acha, 2 months plus
2
1 month.
months.
84 is the provision for appeal, my lords.
85.
85,
Section 85 of Service Tax Act.
within 2 months, you know. And there's a condonation also for extra 1 month, I think. Extended period is 1 month, I think.
What will have to happen to Glaxo?
My lords, I'm sorry, my lords, I did not.
Glaxo.
GlaxoSmith. That is there, my
The
lords.
condonation period is also gone.
Yes.
Thereafter you approach in writ.
My lords, kindly see the
Yes,
next
yes,
judgment
yes.
which I'm relying upon. Kindly see the next judgment which is passed by Justice Rajabasu Chaudhary.
Glaxo has
Here, my lords,
considered-
here also, my lords, they had challenged 2023 order in the year 2024.
Glaxo was placed.
No, Glaxo was not, please.
Yes.
My lords, I'll be remediless, my lords.
That
My lords, I have a judgment of the Supreme Court, which is a very recent judgment. It is not a tax judgment, my lords, but here the Supreme Court has reiterated the principle of Katji, my lords, that where the fault is of the advocate or the authorized agent, my lords, the assessee should not suffer because of the fault of his associate, my lords.
That is very well settled.
Yes, my lords, my case is that only, my lords, because I could not approach the court since, my lords, my AR had misrepresented me, my lords.
It has to be looked into in the facts and circumstances of the case. Then affidavits and all have to be invited.
Very well, my lords. My lords, I am ready to go back to the appeal, my lords. I don't have a problem with that. My lords may put me to terms. My lords may impose some cost on me. My lords, but otherwise, my lords, I'll be remediless.
Yes.
My lord, kindly have a look into page number 43 of the writ petition. 43.
Page 40.
That is the order dated 29 September 2023.
Yes.
On the first page, it starts from any person deeming himself aggrieved by this order may file an appeal under section 85 of the Finance Act against the same to the Commissioner Appeal, Horen Mukherjee Road, Hakimpara, Siliguri, within 2 months from the date of its communication. Then mention appeal should be filed in duplicate in form ST4 in duplicate and shall be accompanied by a copy of the order or decision appealed against which should bear a court fee stamp. And in 3 it is mentioned an
Yes,
appeal
I've read
against
it,
the
read it.
yes,
Read it, Mr. Pani.
7.5% after making payment of 7.5%. And order was passed in the year 2023. That is near about 2 months. After 2 years, after a lapse of 2 years now, he has filed this writ petition, which is not maintainable at all. As because there was no violation of natural justice from the order. It is categorically mentioned in page number 49, my lord. Page number 49, operative part of the order. Page number 49, 4.7. Page number 49 of the writ petition, para 4.7. 4.7, 4.8, and 4.9. It is, these paras are very relevant.
Page 49 says that a fresh date of personal hearing on 19th of September
Yes.
2023 was granted. But in
Yes.
the petition, he has said that
Yes.
he has not received any such
Yes.
notice.
This
That
is my
what was told to
categorical.
me.
Yes.
Paragraph-
Several opportunities were given to the petitioner.
You consider Glaxo. Consider Glaxo and then
My lords may send me back to appeal. My lords may impose cost on me. My lords, I'll go back to the appeal court. this matter can be disposed of. They will not be prejudiced, my lords, if I shall file my appeal. They can decide me and thrash me out on merits if I don't have any case, my lords, in the appeal.
But if the appellate authority also does not have power to condone,
My
Yes.
lords,
Yes, that is
with one
appellate-
direction from my lords, everything can be condoned, my lords.
that is there, but seeing Glaxo, I don't think I have that power. Glaxo has specifically.
But my lords will
consider.
consider,
It has said that even under 142 Supreme Court cannot do that. It has gone that
Yes,
far.
yes.
Glaxo is, you please.
I
consider
will consider that.
To consider
I will
Glaxo and
consider.
come.
Very well. My lords will take this up on Friday, my lords.
Third learned advocates appearing for the respective parties. Full stop. List this matter for further consideration on July 11. 20.
Friday. Friday for further hearing.
Right.
Myself, Ratan Bonik for CGST department, my lord.
Yes. Now we will record.
Supreme Court is judgment.
Grateful, my lord.
Service
Good.
tech, wait. Glaxo is a tough nut.
I agree.
Has taken
Difficult.
several judgments and
Yes.
My lords, I appeal for the petitioner in this matter.
Grateful.
Because this is a very short issue involved in this case. This is a penalty I am challenging under 129(3). I am coming after appeal since there is no tribunal, my lord knows. The appeal is maintainable, writ is maintainable. The only issue involved here is, my lords, this is relates to detention of vehicle. I am a contractor, my lords. I had got certain contracts in the state of Manipur for making some road project, my lords. I have my place of business at Manipur as well as in Jharkhand and also at several other places. So one of my own excavator, after completing a job work in Manipur, was returning from Manipur to Jharkhand. In West Bengal, it was intercepted. The only point which is the allegation against me is that
appearing you against you.
state is there, my lord. This was served long back. This matter has been running in the list. He's there. The only allegation here against me is that at the time of interception, I did not submit. My lords, what happens in case of non-taxable goods? You have to carry a delivery challan. My lord knows, is aware. My lords has also seen one case relating to that. The only allegation is that I had not submitted the physical copy of the delivery challan. E-way bill was there. In the e-way bill, the delivery challan number was also there. I had submitted the delivery challan from my phone, the driver. Later on, it was submitted, which was not accepted. There is no allegation with respect to any evasion of tax. So this is their case, my lords. In the appeal, the same point, it was dismissed. I am covered by cases as well.
But the petitioner the driver of the vehicle could not produce the delivery challan at the time of inspection of the vehicle. That is the point. Subsequently, what has happened is that they have paid the penalty. They have released the goods. Now, after paying the penalty, they have come before the penalty has already been paid. Case has already been closed. It's not the case of the petitioner that the penalty remains pending. There's a demand pending. The goods have been released. The vehicle have been released.
No, they want.
The proceedings were also concluded.
They want quashing the penalty order so that they can get the penalty back.
As per the provisions of section 138A, they need to produce a physical copy of the delivery challan, which the driver at that point of time could not produce.
No, but he says it was there in the soft form before.
No, it was not produced before the authorities concerned, my lord. As per my instruction, my lord.
Physical form. My lords will see their allegation from the show cause notice. I'll show. Allegation is
produced
physical form. It was not produced.
Definitely.
And what is the provision?
138A mandates that you have to have a physical copy of delivery challan as well as.
And how is it been interpreted by courts?
Yes, it has been interpreted. That is the pertinent question, my lords. Time and again, our court's division bench as well as Supreme Court has said that when there is no intention to evade tax on part of the assessee, no penalty can be invoked, my lords. Because 129, my lords, has to be read with 130.
Malad,
Otherwise, my lords, this is disproportionate, my lords. My own goods.
Malad, we have to go by the statutory
Yes, my
provisions,
lords.
because the statutory provisions.
I
have
will show the
mentioned
judgments, my
The
lords.
physical copy need to be produced.
Very well. If he has the physical copy on that day, he did not have it for that.
Well,
he
it has to be
penalized.
produced at the time of the inspection of the vehicle, which was
Very
not
well.
done.
Suppose he did not have it at all.
Well,
And therefore he could not produce it. It has to be read meaningfully.
Lordship,
I could not produce it at the time of inspection because I did not have it at all. Is one thing to say.
That is-
right. Penalize him. I did not produce it. I could not produce it at the time of inspection because I did not have it at that time, but that is in existence. I have it in my name. It's there. But at that point of time, it was not there.
but it is not
Should I
the,
be penalized?
it is not the case of the.
What is the logic? What is the objective behind insertion of these kinds of
Yes.
provisions? The objective is
Not
so
the
that
tax-
the person
it cannot-
so that
tax
the
evasion is not
person
there.
does not
Evade.
go away without paying tax.
Yes, there is no tax
If
evasion.
taxes have not been evaded, he is having that document merely because it could not produce it. Penalizing would be
And my lords, appellate
But,
authority has.
we-
very.
Our hands are tied because we have to go by the statutory provisions. That is the only.
That is, courts have interpreted it.
Yes.
Lordship.
My lords, I'll place one judgment covering the same issue of this court. In my case only, my lords. Paragraph 2 and 3 are the facts. And 10 onwards is the finding.
138A.
Here also physical copy of tax invoice was not there.
And there's a difference between physical copy of the tax invoice. and
Tax
the-
invoice is worse,
That-
my lords.
that
That's
is
I am in a better footing
There's
because
a
tax invoice means the goods was taxable. Here it's a delivery challan. I am
Because
on
it
a
is an
lower
out-
footing, my
It
lords.
is one, it is an
I stand
inward
on a
supply.
better footing than this
It
case.
is not even an inward supply, it is an outward supply.
This
From
is
one
not a
state-
supply, my lords. This is not a case of
From one
supply.
state to another.
I was not making any sales, my lords, here. And supply is defined under the act. This is not a case of taxable supply. In fact, their appellate authority has said that this is not a case of tax evasion. I can show that from the order.
Show me.
Page number 66 onwards, my lords, is the appellate authority's order. My lords will directly come to page number 68, the middle paragraph. It starts from 66. Operative part 68, the middle paragraph. This appellate authority finds it is pertinent to note that it is case not on levy of tax, nor it is a proceeding on the evaded tax, but it is a case of regulatory provisions of goods in movement under 168.
Yes, that is what I have.
This is their finding, my lords.
So I was also saying, because
And my lords, one important thing, my lords, kindly take page number 25. This is the e-way bill, my lords.
Yes.
There is the document details, my lords. Challan HRC 2425 1 24/7 2024. My lords, read this with page number 27, which is the delivery challan.
Page 25.
25 is the e-way bill, my lords.
Yes.
It refers to the delivery challan, the document details, which they allege that I did not produce.
Where is
In the top part, my lords, approximate distance below that.
e-way bill details is there?
Yes, my lords, over there. The third line, middle.
Document details.
Yes. The challan number, my lords, will see HRC 2425 12407. Read this, my lords, with page number 27, which is the delivery challan, which I had produced before the authorities later. So this was there in the e-way bill, my lords, the document reference number.
And what did the driver have?
he did not have.
The driver had
He did
the
not
e-way
have
bill.
the copy of the challan at all.
E-way
According
bill
to us, he
and-
did not have it.
E-way bill is mandatory. Along with that,
He-
delivery challan is also
He
mandatory.
had the e-way bill,
Where
did
is
not
the
have the
provision?
delivery challan. at all.
Provision, my lords, I'll show. 138A, my
Malad
lords.
takes up 138A.
You will have to help me with it.
Yes, my lords.
Yes.
Certainly.
Rule 138A of the CGST, WBGST rules.
138A1.
A1.
The person in charge of conveyance shall carry invoice or bill of supply or delivery charge as the case may be, and a copy of the e-way bill in physical form or e-way bill in electronic form or mapped to the radio.
Frequency
number.
identification.
My lords, kindly take section 129, where the penalty has been imposed.
Page
129, my lord, section 129.
129.
Yes.
Yes.
Notwithstanding anything contained in the act where any person transports any goods or stores any goods while they are in transit, in contravention to the provisions of this act or rules made thereunder, all such goods and conveyance used as a means of transport for carrying the said goods and documents relating to such goods and conveyance shall be liable to detention or seizure, or after detention or seizure shall be released. Because this is important, on payment of penalty equal to 200% of the tax payable on such goods. Here, my lords, my tax is not payable. Second part, I shall be, if
No,
my
that's
case is that, my lords, even if they invoke 129, then I will fall under the second limb. And in case of exempted goods, on payment of an amount equal to 2% of the value of goods or 25,000, whichever is less, where the owner comes forward for payment of such penalty.
The payment of penalty has
And,
been
my lords, I'm squarely
2%
covered.
or 50% of value.
No, 2% or 25,000, whichever is lesser.
But in my book, it's written on payment of penalty equal to 50% of the value of goods or 200% of the tax payable.
My lords,
Which
129 1A.
1A.
A is on two
Achha.
parts. First is for tax payable. Yes. Then is the second part.
2% of value of goods or 25,000.
Whichever is less. And my case is that I'm covered by section 126. My lords, kindly see section 126.
Well, the penalty amount in this case has been recovered under section 129 1A.
Yes, that is why I'm showing 129.
Penalty has been recovered under section 129 1A.
My lords, kindly see 126.
Yes.
No officer under this act shall impose any penalty for minor breaches of tax regulation or procedural requirements, and in particular, any omission or mistake in the documentation which is easily rectifiable and made without fraudulent intent or gross negligence. Explanation is also there, my lords. Breach shall be considered minor breach if the amount of tax involved is less than 5,000 rupees. It is their admitted case that this is not a case of tax evasion. And tax is zero here because this is I am just transferring my own vehicle. And part B also, my lords, an omission or mistake in the document shall be considered to be easily rectifiable if the same is an error apparent on the face of record. Subsection 2 is also very important. The penalty imposed under this act shall depend on the facts and circumstances of the each case.
This is more important.
And shall commensurate with the degree and severity of the breach. Milords, recently the Delhi High Court, in a very elaborate judgment, Milords, this is a long judgment. They have basically, Milords, here the court has held that in section 129 cases, 126 becomes very important. And they have, because the department's argument was that 129 starts with a notwithstanding. It's a non-obstant clause. So it will override everything. So that thing was dealt in details, Milords. From paragraph 1 is the facts of the case. Here the case was that the part B of the e-way bill was missing. As a reason of which they had imposed penalty.
Do you have any case on the delivery challan missing?
Yes, Milords, I have. Please see there.
How has that been interpreted?
The delivery challan also I have. Nahi laya kya? Oh. Because I did not carry that. I have that on the same point, but from no, Uttarakhand High Court. From the Uttarakhand High Court I have. On the same point, delivery challan was not there. Milords, but the case I have placed Shekhar Kumar, Milords, there also it's the same point. Paragraph 21 onwards, Milords, will find the reasoning which has been given by this court. Here also I had not produced the physical challan of the physical copy of the 22, 21 onwards, Milords, will 22, 23, 24, 25 will cover me, Milords. Paragraph 22, 23.
In case more appropriate would be 24. 24 would be more appropriate.
About the same. 24 also, my lords, the paragraph which they have relied on the division bench judgment, that also I shall place, my lords. There also very clearly our court, division bench has held that where there is no difference in the quantity, no 129 should be levied. Paragraph 3 is the.
And in all fairness, I should submit that paragraph 24 is in favor of the bench of the earlier judgment, as to the division bench judgment of the Honorable High Court.
Where are the orders? Please give me the dates. Show cause notice, page.
Show cause notice 43, 45 is the show cause notice. And 50 onwards is the order.
I appear for the petitioner. But on the last occasion, your lordship was pleased to pass an order that your lordship will kindly peruse that order. Directed my learned friend, my lord, to produce, my lord, the attachment order in connection with which, my lord, I am challenging the freezing order.
Yes, my lord,
My lord,
I beg to appear on behalf of the.
and I'll
enforcement
answer on the
directorate.
point of, my lord, the locus standi, which, my lord, on the last occasion, Mr. Trivedi was, my lord, he was very vociferous about the locus. I'll reply on my locus.
Well, my lord, I beg to appear online, my lord. Mr. Singhania is appearing physically. My lord, he is having the copy of the attachment order, provisional attachment order. He will hand over to your lordship for the convenience.
But will kindly, my lord, see the name of the petitioner
My
and
lord, I
whom
will.
the attachment order has been not issued.
Yes, yes. My lord, my learned senior will kindly allow me some time to place it. Thereafter, he will definitely address this honorable court on his submissions. My lord, the first point is I will request Mr. Singhania to hand over the attachment, provisional attachment order
Yes,
which
we
is
have received it. Have received.
number 06 of 2025, dated 21st June 2025.
Have received it, received it.
And thereafter, I will request Mr. Singhania to hand over the acknowledgement receipts of Mr. Prasanna Kumar Rai and Mrs. Kajol Soni Roy.
But
Both
they are
are
not the
dated
petitioners.
24th of June 2025.
That's it. Last 3 pages, sir. First mail and second acknowledgement receipt. First 3 pages via
One
mail, your lordship.
acknowledgement receipt, your lordship will find that we addressed to the learned superintendent, Presidency Correctional Home for service of the copy of
Yes,
provisional.
I've seen it, seen it.
Yes. So both of them have acknowledged. Now the question comes to whom the provisional attachment order has been served. Whether this provisional attachment order, if your lordship takes up, your lordship will find the provisional attachment order. It is of 56 pages. I would request your lordship to come directly to the page number.
But since my learned friend is relying upon that, my lord, in defense of my case, my lord, may I be permitted to have a copy? Because I am unable to assist your lordship on the point Mr. Chakraborty is trying to impress upon your lordship without a copy. And although, my lord, I am not the person upon whom, my lord, the notice has been served. I'm a different person also.
Yes, that I've seen.
Lordship.
That I've seen. Yes,
But-
Mr. Chakraborty, why should he not have a copy of it if he's?
Well, after I finish for 5 minutes, if your lordship directs me, if your lordship so pleases to find that he is entitled for a copy, that copy is not a problem. First, let me make out my point. Thereafter, if your lordship directs me, I will comply with that. My lord will kindly see, come to paragraph, page 11 first.
Page 11.
Yes, my lord, paragraph 19. Here your lordship will find that transaction details with respect to Samsung Organic Tea Private Limited. Here your lordship will find the details of the account numbers, and the third column your lordship will find the name of the account holder. Here your lordship will find all names are pertaining to Prasanna Kumar Roy and Kajol Soni Roy. 8 accounts. Thereafter, if your lordship goes to table number 3, your lordship will find the details of cash transaction. Thereafter, table 4 is also cash transaction. Table 5 is again the account details of Prasanna Kumar Roy and Kajol Soni Roy with respect to this particular tea garden, the transfer details. Table 6 is also with respect to the transfer received to this tea garden. Now, my lord, I will not trouble your lordship much with this. Your lordship may directly come to all the details, transaction details. Your lordship will find one after another pertaining to the tea gardens under question. 2 tea gardens are before your lordship today with respect to 2 tea gardens. Now your lordship will kindly directly come to the properties attached. The list of properties which have been attached under this order of provisional attachment dated 21st of June. The list of those properties your lordship will find that I will kindly bear with me for a minute. My lord, at Schedule A at page 54.
Yes.
My lord, will kindly see the type of property at the first column, then the owner of those properties in the second, third, fourth column respectively, and the total value at the last column. My lord will find that we have provisionally attached building and structure, plant and machinery, and vehicles belonging to Messrs. Samsung Organic Tea Private Limited, Messrs. Youngtang Organic Tea Private Limited, Messrs. Bamandanga Tea Estate Private Limited. The total value of the attached property is rupees 27.192. Now, my lord, I can go through the entire provisional attachment order. I'm not wasting the time, my lord. These three tea gardens or the tea factories, Mr. Prasanna Kumar Rai and his wife, Ms. Kajol Soni Roy, has invested substantial amount of proceeds of crime in these three tea companies. Now, the investigation under PMLA shows that Prasanna Kumar Rai, who is presently at judicial custody, is involved in the scam of SSC recruitment of Group C and Group D staff, as well as in the assistant teacher, but this is pertaining to Group C and Group D. Now, the scam generating the huge proceeds of crime, in the scam where these persons have already went up to the Honorable Supreme Court of India, your Lordship is aware of, and the Honorable Supreme Court has also found that untainted and tainted could not be separated, and tainted persons have been employed against monetary consideration, which is illegal in nature, and all their services have been struck down. Now, that predicate offense generated huge proceeds of crime. A part of that proceeds of crime went to Prasanna Kumar Rai. Prasanna Kumar Rai and his wife, Kajol Soni Roy, the transactions I was showing your Lordship in different tables have been narrated. How this money trail has been found. Now, they have invested the proceeds of crime into these tea gardens. Now, according to Section 21U, read with Section 21V, I would request Mr. Singhania to hand over a PMLA to your Lordship. If your Lordship kindly take Section 21V for a moment. But first 21U, then 21V. Now 21U, my lord.
Yes.
This is definition of proceeds of crime.
Proceeds of crime.
Correct. Miller. Proceeds of crime means property derived or obtained directly or indirectly by any person as a result of criminal activity relating to the scheduled offense, or the value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. For the removal of doubts, it is hereby clarified that proceeds of crime include property not only derived or obtained from the scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of a criminal activity relatable to the scheduled offense. Now, my lord, I am reading the definition of property in clause B. Property means any property or asset of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and includes deeds and instruments evidencing title to or interest in such property or asset wherever located. Explanation. For the removal of doubts, it is hereby clarified that the term property includes property of any kind used in the commission of an offence under this act or any of the scheduled offence. Now, my lord will kindly come to section 5. Where the director or any other officer not below the rank of deputy director authorized by the director for the purposes of this section has reasons to believe, the reasons to for such belief to be recorded in writing on the basis of material in his position, that any person is in possession of any proceeds of crime. But pausing here for a moment, in this case, the directorate has the reasons to believe that Prasanna Kumar Roy and Kajol Soni Roy are in possession of proceeds of crime. Then, I am reading again from the section. And such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceeding relating to the confiscation of such proceeds of crime under this chapter. He may, by order in writing, provisionally attach such property for a period not exceeding 180 days from the date of the order in such manner as may be specified. So, my lord, when the directorate or authorized officer will find that any person is in possession of a proceeds of crime, he, by an order under section 5, subsection 1, can provisionally attach that property. Correct, Miller? Now, kindly take section 8.
Yes.
My lord will kindly see subsection 1. On receipt of a complaint under section 5, subsection 5. But I'm sorry, I should have read section 5, subsection 5 first. But I will kindly take section 5, subsection 5 for once.
Yes, I've read it.
Yes. So 8.1 says, on receipt of a complaint under subsection 5 of section 5, or application under subsection 4 of section 17, or under section 10 of section 18, if the adjudicating authority has reasons to believe that any person has committed an offence under section 3 or is in possession of proceeds of crime, it may serve a notice, well, that is show cause notice, of not less than 30 days on such person, calling upon him to indicate the source of his income, earning, and assets, out of which or by means of which he has acquired the property attached under subsection 1 of section 5, or seized or frozen under section 17 or section 18. The evidence on which he relies upon and other relevant information and particulars, and to show cause why all or any of such properties should not be declared to be properties involved in money laundering and confiscated by the central government. So, my lord, if I may put it in this way, the procedure under the law is, when the directorate has reasons to believe that any particular property, whether movable, immovable, tangible, intangible, is a proceeds of crime and likely to be concealed or alienated, he may, by an order under section 5, subsection 1, can provisionally attach it. Immediately after doing that, within 30 days under subsection 5 of section 5, he will file a complaint before the adjudicating authority, who is an independent authority created under section 6. Now, after receipt of that complaint, the adjudicating authority will apply his mind, independent mind, in the complaint. Thereafter, if he finds that any person is involved in the offence under section 3 or any property is proceeds of crime, he shall issue a notice upon such person, asking him to show cause and show his income, show his legitimate claim before him that this is not a proceed of crime or I am not an offender. Then he will consider that in the following subsection of section 8. So the procedure requires that I, having reason to believe, will provisionally attach the property, and I will send a complaint, or I will file a complaint with respect to the same under subsection 5 before the adjudicating authority. Thereafter, the adjudicating authority will issue the show cause notice and the process of adjudication will be taken up, where the person concerned will have all the opportunity to disclose his source of income, earning, or asset out of which or by means of which he has acquired that property. So he is to join in the adjudication proceeding. Now the question comes, what my learned senior friend opposite at the very outset, before I could say anything, has pointed out that his client, that is the petitioner before your lordship, is not being served with a copy of this provisional attachment order. My lord, the question comes that my learned senior DSGI was addressing your lordship on the last occasion. At the very first moment, he has pointed out that this petitioner has no locus because the property, I have showed your lordship, the property we have attached, provisionally attached, or rather against the order of freezing here before this honorable court, the earlier frozen, now provisionally attached, these properties are belonging to the Tea Garden Company. Now, the Tea Garden Company owners are Prasanna Kumar Roy and that Kajol Soni Roy. This particular gentleman before your lordship or the company that are namely Merchant Mongar Agrotech Private Limited are not the owners of any of the properties. They say that they are before this honorable court because they have entered into a bipartite agreement with the Tea Garden Workers Union to manage and control the tea garden for the welfare of the tea garden laborers. But very well, let us assume he has that authority to manage and control the tea garden. But that does not make him owner of any part of the property we have provisionally attached. So his locus does not come. Now, if he, my lord, what I suggest, my lord, if he feels that he is owner, if he feels, because title deeds does not show that he is owner, and we are not liable to serve him. If he feels that he is owner, so what is the proper recourse, my lord? He is to make an application before the adjudicating authority, saying that, see, I have not been served with, but I am the owner of this property. I am showing my titles, my title deeds. Then it is for the adjudicating authority to see. It is not for the investigating authority to decide, because we are going by the documents, titles, and deeds. And we are going through a statutory provision which provides a complete mechanism. Even after the order of the adjudicating authority, my lord will find that is appealable before the tribunal. After the order of tribunal, that is appealable before the Honorable High Court in division bench. So the complete mechanism.
I'll come back to you, Mr. Chakraborty. I'll come back to you.
My lord.
I'll hear Mr. Mukherjee. I'll come back in 5
Yes,
minutes.
Lordship.
I'll come back to you after hearing Mr.
Smile. Deeply blessed.
Sorry. Yes, Mr. Mukherjee, locus.
Blood, I think Mr.
Malad,
Chakraborty
I
has,
have
blood.
one more
Otherwise, blood,
submission.
he will rebuke me, saying that I'm interrupting him.
But I have one more submission.
Let him complete, blood.
My lord had taken less than 5 minutes even.
Yes.
So, my lord, one more thing I should point out. I was showing the provisional attachment order. Your lordship will once again take that provisional attachment order, page 10.
Yes.
Page 10, paragraph 17.
Yes.
Right, my lord? So here we have found during investigation from Prashanna Kumar Roy and his wife Kajal Soni Roy that how they have acquired these three. Table 1 is the details of three tea garden companies. How these three companies they have acquired, on which date they have acquired. I have given the details over there, and the shareholding pattern. In the three companies, your lordship will find 50-50% for Prashanna Kumar Roy and his wife. So the entire property of these three gardens are belonging to this particular two persons. Now the last thing, my lord, will not take me at amaze, my lord. The writ petition, my lord, is directed against an order of seizure or freezing under section 17, which are dated 30th May 2025. Now, my lord, today this writ petition has become infructuous because on 21st June, section 5 has been invoked for provisional attachment, which is of higher degree. And these properties, which were initially seized or frozen under section 17 on 30th May, have now been provisionally attached under section 5 on 21st of June, which I have produced before your lordship. So the writ petition and the prayer pertaining to the freezing order dated 30th May has become infructuous today. So, my lord, I am praying for dismissal of the writ petitions.
Yes, Mr. Mukherjee.
Now, Lord, your lordship will kindly come to, Lord, the freezing order. And kindly see, my lord, to whom it was addressed. Because, Lord, my learned friend, Lord, by now, your lordship has seen that the attachment has been directed against the erstwhile company who was operating, Lord, the tea garden. The land in tea garden, Lord, are never belonging to any company. It is not the state of West Bengal who owns under the and settles under the West Bengal Estates Acquisition Act and Land Reforms Act for a long-term settlement. So, Lord, the land of a tea garden is, Lord, not belonging to any person or a company. And Lord, I do not know whether there has been any attachment of a government property by the ED or not, because I am not privy to the document.
Land has not been attached.
Very good. So, Lord, all that we are on a 27 crores that they, Lord, say to have attached, Lord, I take it to be, Lord, the machineries and, Lord, the trucks and all these things, which, Lord, they might have, Lord, enumerated there. I'm not privy to that particular document. But here, Lord, on answering your lordship, Lord, on the point of, Lord, the locus standi, Lord, when a notice is addressed and, Lord, a freezing order is addressed to my client certainly do have, Lord, the locus standi. Because the notice is addressed to my client, the second page, your lordship will find Anjan Bhaduri, copy to Merchant Monger Agrotech. Page 91, I mean to say, Lord. So Merchant Monger Agrotech is, Lord, the petitioner before your lordship as a company. Now, who is this company?
Yes.
Now, Lord, your lordship will kindly come to, Lord, the government notification at page 34. Now, Lord, kindly omit, Lord, the previous, my lord, that, Lord, about 6-7 lines. Now, my lord, the state government has formulated a standard operating procedure. Your lordship has seen, my lord, that portion about, my lord, 7th line from top. The state government has formulated a standard operating procedure for short-term settlement for operating and regularizing of the tea gardens, lands whereof are under the ownership of the government of West Bengal. Having vested in terms of the provisions of the West Bengal Estates Acquisition Act 1953, which are abandoned, closed, and/or are being operated by virtue of bipartite agreement with operating trade unions, and for the reasons mentioned in the said SOP. So, my lord, on the last day, there was an argument, my lord, that how can I, my lord, on the basis of an agreement with the trade union, operate? I do not never say, my lord, that I am a owner. On the very first day, I said that I am operating on the basis of a government notification. Subsequent, my lord, there was an agreement. Then, my lord, pursuant to this notification, I have an agreement on the next page. I have applied for an agreement. My learned friend appearing for the state government will be in a better position to apprise your lordship about, Lord, how do they look at, Lord, my agreement. This, Lord, page 35 is made pursuant to the notification, Lord, that I have just shown at pre-page. So, Lord, now pursuant to, Lord, this application, I have obtained bank loan. I means, Lord, the petitioner before your lordship. The bank loan documents are at page 41 to 89. But the very purpose is, Lord, that the government wants, Lord, that the laborers in the closed tea gardens, at least they can survive. Somebody comes in, operates the tea garden, the laborers are not starved, and there is a social purpose behind it. My client has, Lord, until unless he operates for a clear 1 year, he cannot, Lord, apply for a short-term settlement under the SOP. That's the policy. So, Lord, he has from 2003, Lord, in operation, 23, I mean to say, in operation of, Lord, this particular tea garden. There's no dispute about that. Now, Lord, he has also applied for, Lord, the short-term settlement. Now, Lord, the notice is directed to my client about, Lord, the freezing order. Now, Lord, if the freezing order is directed against my client and it is, Lord, later substituted with an attachment order in respect of, Lord, the owners, the question that I asked to myself, Lord, a person who has been notified about the freezing order, who is in operation of, Lord, a particular tea garden, he does, Lord, have a locus standi to challenge the freezing order. Now, Lord, why I am before your lordship about challenging the freezing order, and what's the distinction between, Lord, an attachment order and a freezing order? If, Lord, section 5 was, Lord, what that was there in the, Lord, the statute, there was no necessity of, Lord, section 17. So, Lord, it does, although, Lord, it overlaps at one point of time, but it does have a separate, distinct, Lord, purpose. I'll assist your lordship, Lord, by citing a couple of decisions on the point. Lord, there are, Lord, a few decisions which elucidate the purpose of 17 and the purpose of, Lord, attachment. So, when Mr. Chakraborty has taken your lordship through the scheme of the statute of attachment, your lordship must have marked, Lord, that the attachment order is first a provisional attachment order. It is at the level of, Lord, the officials who go and really, Lord, do the ministerial work based upon a subjective satisfaction of the director or the deputy director. Then, Lord, they have to, within 30 days, Lord, put the question about the propriety of the attachment before, Lord, the adjudicating authority appointed under section 6. Then, Lord, the adjudicating and this attachment order at the most, Lord, can survive for 180 days. So the very purpose of an attachment or, Lord, in a lesser degree of freezing order is, Lord, to, as they say, is to protect and realize from the alleged proceeds of crime the money. So why I am before your lordship is, Lord, that this particular, Lord, the freezing order, I am not the owner, I cannot sell. But whether the procedure, Lord, adopted by, Lord, the ED in freezing my property is proper or not, and secondly, whether that creates the embargo in, Lord, utilizing of, Lord, these machineries for the purpose of continuing production. Because the dominant purpose is to, my lord, in the event of their success, they sell and realize the money. So on the very first day, I had twofold suggestion to my learner friends. If you want to take the properties which you freeze, you take it away, sell it, put the money somewhere where you want to keep it. Judgment গুলো দাও দুটো। Now today, my lord, whether I'm entitled to an interim order or I'm not entitled to an interim order, that is not where I'm arguing as of today. Now, my lord, kindly come to, my lord, the text of the freezing order. Because once I place that, then, my lord, I'll take your lordship to the judgment. Page 90, my lord.
Yes.
Now, my lord, whereas I, Ramchandra, Assistant Director, Directorate of Enforcement, have been duly authorized by Arun Gopal Pandey, Deputy Director, VDA authorization number 60, dated 29/5/2025. But this authorization number 60 of 29 May 2025 to conduct search and seizure, freezing under Section 17 of the Prevention of Money Laundering Act. But this records, my lord, the subjective satisfaction of the director or the deputy director as to whether, my lord, he should conduct search and seizure for the purpose of freezing or not. That similar type of language your lordship will find in Section 5. Then, but this authorization number was never produced, not shown, nor produced before your lordship in course of, my lord, this argument. To conduct search, seizure, freezing under Section 17 of the Prevention of Money Laundering Act at the premises of Bamundanga and Tandu Tea Estate, situated such and such, and whereas during the course of the said search, several items such as machineries, vehicles and bungalows as detailed in the Annexure A were found and identified as being relevant for the purpose of further investigation under the provision of PMLA 2002. And whereas it is not practicable to seize the said item of machinery due to their size, nature, location. Now, therefore, in exercise of the powers conferred under Section 17(1)(a), I hereby order freezing of the machinery listed below to ensure their availability for investigation and to prevent any unauthorized use, transfer, or disposal. Lord, kindly mark the word unauthorized use. Now, Lord, it is hereby directed that no person shall remove, part with, possession of, deal with, or otherwise dispose of the aforesaid machinery in any manner whatsoever without the prior written permission of this office. Any contravention of this direction shall be deemed to interfere with the process of law, may attract legal consequence under the Prevention of Money Laundering Act. Now, Lord, qua this, your lordship will see, Lord, the words used here, unauthorized use, transfer, or disposal, in the second last paragraph of page 90.
Yes.
And secondly, directed that no person shall remove, part with possession, deal with, or otherwise dispose of the aforesaid machinery in any manner whatsoever without the prior permission. Now, Lord, kindly have a look at, Lord, the Section 17. Apart from the propriety of, Lord, how the seizures are conducted, but your lordship has a book down. Lordship. But kindly, Lord, turns over to Section 17, which deals with, Lord, this particular, Lord.
Yes.
But Section 17, first part is, Lord, the subjective satisfaction of, Lord, two ranked, Lord, officers, director and any other officer not below the rank of deputy director authorized by him. They say, talk about the authorization number 60 before, my lord, the date they conducted the search on 30th of May. On the basis of information in his possession has reason to believe, reason for such belief to be recorded in writing. But kindly mark this. It is not that, my lord, that I feel that there should be, my lord, a search in the property of XYZ. So, my lord, what he has to record is, my lord, I, and 4. Then, subject to the rules made in this behalf, because when I take your lordship to the rules, my lord, the rules also lay down how it is to be conducted. In the presence of, my lord, the witnesses, Pachnama has to be executed. He may authorize any officer subordinate to him to enter, search, break open, seize any record or property found as a result of such search, place marks of identification on such record, make a note or an inventory of such record or property, examine on oath such and such. Then, my lord, 1A, the power which has been exercised by, my lord, the officer concerned is 17(1)(a).
Where it is not possible to
Practicable. May make an order to freeze such property, whereupon the property shall not be transferred or otherwise dealt with, except with the prior permission of the officer making such order, and a copy of such order shall be served on the person concerned. So there are two, my lord, things embargoed: transferred or otherwise dealt with. On the last occasion, your lordship has recorded my submission that it should be dealt with ejusdem generis. Now, my lord, the order which I have shown before your lordship under challenges, my lord, that he has, my lord, given an embargo which is, my lord, much more than what, my lord, that is not permissible in the statute. That is why, my lord, he has gone. Now, secondly, my lord, when I take your lordship, my lord, to the propriety of, my lord, the manner in which, my lord, that it has to be done, my lord, your lordship will kindly, my lord, I'm জানি না তোরটা তো রুলসটা আছে 2005 এর রুলসটা,
হ্যাঁ আছে, হবে, হওয়ার কথা।
but may I just have a lord,
এটাও দেখে নাও।
হ্যাঁ এটা
সবে ওখানে ওখানে আছে আমারটা, তো এই যে এখানেও আছে।
আচ্ছা তোর বইটাতে আছে না?
ওটাতে আছে, এটাতেও
আর
আছে।
পেজ এই বইটা কি জজ সাহেবের কাছে আছে? ও তাহলে তো পাতা মিলবে না।
আমি তোমার
But will kindly, my lord, take this rules, my lord. I think that is there, but my lord, for the ease of, my lord, referring it. Rules. না
এটাও না,
এটা না,
এটাও না।
2005 ওটা তো অ্যাটাচমেন্ট রুলস, এটা হলো তোমার ফ্রিজিং। Lord, will kindly see, Lord, the manner.
Well, senior is referring to which rule, Millard?
The name of the rule has 5 lines. The prevention of money laundering, form, search and seizure or freezing, and the manner of forwarding the reasons and material to the adjudicating authority. Impounding and custody of records and the period of retention rules 2005. That's
Very
the
well.
name of the rules I referred to.
Very well. Thank you.
Lord, here your lordship will find, Lord.
But it's not matching with the caption. This is only forwarding of copy of provision.
But then I have, Lord, possibly, Lord, given your lordship, Lord, maybe the wrong rules, Lord, I pointed out. I'll just, Lord. May I have the copy of that book?
আমারটাতেও আছে।
Millard, this will be the rule under notification number 445 within bracket capital.
This one. Lord,
Most of the rules are named same, almost same.
But search and seizure, all these things are not written in the caption, which you read.
No, this is not,
এই যে এটা
You read a lot more than.
period of retention rules.
Notification number DSR 445.
2005. That is what the.
I would request my learned senior opposite to follow the notification number just below the name of the rule,
DCR 445E
445E.
E গোপালদা এইটা কি 445 এটা বলছো?
হ্যাঁ হ্যাঁ
দিয়ে দেবো কত?
হ্যাঁ।
দিয়ে দেবো স্যার?
But kindly have a look at Lord, this rule number 4. It's তোর বই না রে?
Yes, rule number 4. I have it in this copy.
Your Lordship, Lord, your Lordship will kindly have a look. এটা তোর বই তো? হ্যাঁ না না আমার কাছে আছে।
Procedure relating
Thank
to
you.
seizure or freeze.
এটাও বের করে দিচ্ছি,
Lordship.
তোমাকেও বের করে দিই দাও।
আমার বই নিয়ে কেন বলছো? What about me? You'd like to find it.
Here also, Lord, 1A shall not be transferred or otherwise dealt with except with the prior permission. The authority shall prepare a seizure memo, inventory or in form to appended to these rules, which shall be delivered to the occupant of the building, place, vessel, vehicle or aircraft searched. So, Lord, it is, Lord, directed to the occupant. On the question of propriety, on the question of locus.
Yes.
So, Lord, even the rules say that, Lord, it can be, Lord, given to, Lord, the occupant. And, Lord, I have shown before your Lordship, Lord, the freezing order is directed to the occupant itself. So, Lord, when it is directed to an occupant can always come before your Lordship to complain about, Lord, the propriety of, Lord, the freezing order that has been given, irrespective of the fact whether an attachment of the properties, I do not know whether the self-same properties or not, have been proceeded against the alleged, Lord, the owner, whom Mr. Chakraborty says that there are reasons to believe that this is bought out of the proceeds of crime.
But Mr. Mukherjee,
My lord.
suppose on the face value, I accept your argument that yes, you have locus, you have a right to challenge the order of freezing.
Lordship.
I desire to enter into the merits.
Lordship.
Now, if I am faced with an order of attachment at the threshold.
But that is not there on record before your Lordship,
No, I have-
not against,
I have
Lord,
been-
my client.
I have been shown this.
Lordship.
The property in respect of which there is an order of freezing and the property in respect of which there is an order of attachment are the same or is the same. If this is the case, then even if I interfere with the order of freezing, that will be a futile order.
But not necessarily so. Why I say?
Because if
Why
I
I say?
interfere with the order of freezing, the order of attachment still remains. I
But-
have not touched that.
I'm also not challenging that before your Lordship.
So will I pass a futile writ?
Lord, this is first of all, Lord, if your Lordship is satisfied about, Lord, the process of freezing, and if my learned friend says that, Lord, the freezing order has now been, Lord, superscribed by, Lord, the attachment order, therefore, Lord, they should, Lord, either cancel the freezing order or your Lordship should say that the freezing order should not operate in the field. The other way of putting, Lord, the question to Mr. Chakraborty, because his argument was such that now there is a subsequent attachment order, my writ petition has become infructuous. So, Lord, now the other question is, Lord, we have not even examined, Lord, the items that they have listed in, Lord, the freezing order will never, Lord, be 27 crores as they allege. Because once I take your Lordship to the items that they have freezed, these are basically, Lord, those old 50-year-old, Lord, the machineries which are used for, Lord, tea and production of, Lord, tea. That is, Lord, drying of the tea and the different stages of its production. One or two, Lord, the trucks, ambulance is there. There is a old, Lord, the bungalows in the tea gardens are there. Lord, I do not know how they are valued at 27 crores, but it is up to the ED, Lord, to satisfy. Now, as of today, now, Lord, why I am before your Lordship with the freezing order? Lord, I get the freezing order, Lord, it otherwise doesn't pinch me, accepting the fact that there has been a procedural irregularity. And I apprehend that ED may act against me if Lord, the machineries are Lord worked upon. So this is not exactly where I
The
am.
order of attachment operating, still you cannot work with the machineries.
No, even attachment does have a similar empowerment. The attachment, freezing, everything is it doesn't say that there should be an absolute that non-operation of a machine. All that the purpose is that I attach a property in everything. That I have in the event of success, I sell that, I appropriate money, and it is to be restituted to where it should go. This is the purpose of an attachment. Even in a civil procedure code, your lordship knows the purpose of an attachment is in execution of a degree. So here, what the ED is trying to say,
Attachment before judgment.
there is also the
This
order
is-
38
this
rule
is
5.
yes.
Very well. This is this is a preliminary an attachment. The Supreme Court has not given in a judgment the elaborate stages of an attachment in connection with the PMLA Act. That what stages of an attachment are there. But attachment and freezing, as your lordship knows, the legislature does not spare any words. So there are different purposes, in section 17 and section
So
5.
if both of them had to achieve the same means, then two different procedures would not have.
Yes.
Right.
Yes.
They must lead to different situations.
Yes.
And, different goals.
Even when I take your lordship, I'm not wasting my lord's time to say that freezing orders are also temporary orders. Freezing orders are which are done by your lordship has seen that it has to go to the adjudicating authority. So if they have attached the property which the claim of Mr. Prasanna Kumar Rai, I am not Prasanna. So the person whose property they claim to have attached, he has a recourse before the adjudicating authority, provided they approach before the adjudicating authority with the attachment order seeking the retention of the properties. So here, as of today, my locus standi is there, for the reasons I have submitted before your lordship. I'm seeking an interim order limited to that extent, I don't own the property, I don't want to sell the property, excepting, I only apprehend that for the use of the properties in the meantime, which I'm authorized to do by the government notification, the bipartite agreement, and the application before the state government. If I do not use this machineries, the operation of the tea garden will be at a limbo, for which the ED is never benefited. ED is only to secure the money which they assume to be brought from the proceeds of crime. I'll just rely upon two judgments on the point, and I hand it over to my learned friend to apprise your lordship for any other points. Lord, 2021 volume 6 Supreme Court cases, page 707. Lord, I have a copy for your lordship. But extra to nahi. Ache? Oh, acha. हाँ. Kishan ka tha?
May I request Mr. Mukherjee to repeat the citation, please?
Sure.
2021 6 SCC 707.
707. Very well. Thank you.
Lord, your lordship will kindly paragraph 6, 7, 8. এটা একটা আছে, এটা তো লিখে নেই, কপি নেই আমার কাছে।
পাঠিয়ে দিতে
সিঙ্গেল বেঞ্চ ক্যালকাটা হাইকোর্ট,
আন্ডারকোট
ওই লিখতে দিয়ে দিচ্ছি।
খুলে দিচ্ছি।
Then 8, 12 and 14. I'm only placing the, not the relevant paragraphs, ratio.
Paragraph 8, 12 and
14.
কিন্তু পড়বে এখনো পড়েনি। 22
This is more on the authorization part.
There are other judgments at this stage. I'm not bothering your lordship, lord. Even the propriety was challenged. There are certain lord observations. I can give your lordship the citation, but I'm not citing it because lord, that's
No,
a
but,
very longish judgment.
authorization will come before me if affidavits are called for. At the
Yes.
stage of.
Even not
interim
prima facie, that the Supreme Court at
This was decided on affidavits.
this was because the Supreme Court says that even in the affidavit, they are trying to improve upon the case. But here,
Yes,
lord, my
but
case is
Therefore, their stand was there. Now, looking at the order, I can't at the moment say that there was no satisfaction at all.
that is exactly what I say, that lord, that whether there was a satisfaction or not, that is not lord apparent in the freezing order.
No, that need not be apparent. It has to be there.
It is not there.
No, the satisfaction has to be there. Satisfaction need not be shown. For example,
Yes.
in such cases, if I'm a quasi judicial authority or an administrative authority, I need not write my order in the form of a judgment. I may indicate what is there. If on a plain reading of it, I can gather that it is somewhere there in the file, and I can support my conclusion later on. Then in that case, that is all good. That can be taken.
Very well.
But merely because it is not there in the order, I cannot say that it is non-existent. Yes, even if on affidavits I find that yes, it is non-existent, then it is non-existent. It goes. But at the threshold, you show me that which you said that for freezing.
Lord, yes, I rather the single bench decision, but of this honorable court, here the freezing order was not challenged, set aside. But this is reported in Lord 2022 SCC online 2316. But we'll kindly see Lord paragraph 14 onwards. This is a single bench decision.
Paragraph 14.
Paragraph 14.
SCC online Cal 2316.
SCC online Calcutta
2316.
2316.
Thank you.
Paragraph 14.
Paragraph 14, thereafter paragraph 15 and 16. 16 is each of the above 5 condition is required to be satisfied before graduating from 17.1 to the next stage of action under 17.1. Then 17. Then 19. Then 21. Then 22 is my lord, the finding of the learned judge. Twenty-two, 23, 24.
My lord, I'm sorry to interfere, my lord. 2316 2021 SSC online cal is just a preliminary order of 5 pages calling for affidavit of service.
No, 2022.
2022 SCC online to Calcutta 2316.
Not 2021.
202. Sorry.
Yes. But I rest my submission.
But here, what is my lord, the plight of the state government, my lord, and the workers, my lord? And then what prompted us, my lord, to formulate such SOP, my lord? So, my lord, for a little background, my lord, your lordship is well versed that entire this Jalpaiguri and the, my lord, the Darjeeling hilly region area, my lord, is practically is dependent on the tea industry, my lord. And what we have observed recent last 10 years or even for a decade, my lord, that the tea estates, particularly 60 to 70% tea estates or the tea industries, my lord, are fallen sick because of either the owners, I mean that the lessee, my lord, had left the garden as an abandoned way or did not pay the wages or the salary or the statutory benefits and they left. And even, my lord, the dues of the bank even. Then, my lord, keeping in mind in 2024, my lord, may I hand over the SOP, my lord, for your lordship's kind perusal. My lord, the government has come up with a notification, my lord. My lord, kindly see if your lordship at the very first 2 paragraphs, the object and purpose of that, my lord. Whereas some tea gardens in North Bengal have either shut down or are on the verge of closure due to various reasons, including management failure, resulting in closure of operations. Then, my lord, and whereas such closure or abandonment of some tea gardens is resulting in economic hardship for the tea garden laborers due to non-payment of wages besides non-payment of statutory dues payable to the state government. This is the reason, my lord, this notification has come, which is page annexer A. Kindly turn, my lord, the page annexer A. And this is the object, rest it is written, my lord. So straightway, my lord, kindly come the annexer A, the standard operating procedure. My lord, this standard operating procedure for a grant of STS, I mean that a short-term settlement, STS, of abandoned, kindly mark the abandoned stroke closed registered tea garden situated in the state of West Bengal on land which are under ownership of the government of West Bengal, vested under West Bengal State Acquisition Act, shall be applicable. Kindly straightway kindly come D, where this tea estate falls. D. 1D. Tea gardens where leases have not expired. Now the lease has not been expired, but the lessees have abandoned the tea gardens and or kept the gardens closed for more than 3 months and not paid the dues and entitlements of the employed workers, government dues, statutory payments, deposits, and presently being opened, run and managed satisfactorily by the company's individuals, not kindly marked through bipartite agreements between the registered trade unions of the workers and the concerned company individual and the concerned company individual are regularly paying the dues and entitlements of the employed workers and complying with statutory payment deposits and government dues. Then, my lord, if it is complied 1 subclause D, my lord, then what would be the steps taken by the government? My lord, kindly come clause 3 next page. My lord, the tea gardens falling under para 1C and 1D, because my lord, it has shown this 1D, my lord. Above, which are presently in operation by the companies, individuals through bipartite agreements between the workers stroke registered trade union and the concerned company individual may be initially settled on short-term basis with companies individual who are running such tea gardens subject to. Now this is the provision below. Now kindly come A1. 1 year satisfactory running the tea garden since taking over. Then paying all statutory dues, including salaries, wages, provident fund, gratuity, other benefits to the workers, cash or kind at Plantations Labor Act, obtaining the certificate of registration of plantation. Then, my lord, B. The short-term settlement may be period of 1 year initially, with a provision for extension of similar period twice, 1 + 1. Or final settlement by way of lease or rights for 30 years. So, my lord, here what happened with regards to these two tea industry, tea garden, my lord, the gardens were abandoned. Even the Procedural, whatever, because we do not want to fall within this attachment or seizure, freezing, whatever. Procedural was not even, my lord, the lessee in our records. The original lessee, my lord, he left. Somehow, might be Procedural had stepped into by way transferring share, whatever, we do not know. That's not been brought to our notice. Now, in the meantime, what state government found? Then Procedural, when he has taken into a judicial custody, after that for Milord prolonged for 2 years, the garden was abandoned and shut down. There was nobody to look after the Milord, around more than 1,000 workers. It is not only single item Milord or single tea estate left in this way. Various tea estate of a different Milord, reason applied. Then this SOP was invoked. SOP was that for the purpose to protect the workers, Milord, not for any other purposes. Because the workers to be Milord, the prime interest, because Milord kindly sees is a tea industry, is a Milord agricultural based industry, Milord. This is the reason the lease rent and the salami, Milord, at a very meager poultry amount is being charged under the State Acquisition or the Land Reforms Act, so that to give benefit to the Milord, the workers. Now, in this backdrop, Milord, if we see that any entity, individual or company, with the Milord, any agreement with the workers or any trade unions, they are operating the tea garden. Operating means, Milord, paying the salaries, wages, benefits, and the statutory payments to and the meeting the all liabilities, Milord. Then successfully they are running for 1 year, these components. Then we will provide a 1 year short-term settlement. And at the same time, we will process for Milord annulment of the Milord, the cancellation of the lease with regards to the original leaseholder, Milord. Then, Milord, within this period of 1 year, suppose after expiry of the 1 year observation period, short-term period was granted. If any 3 months failure, then immediately without any Milord, notice or any assigning any reason, straightway such Milord, it is also kindly come 4 plus 4. Clause 4. Clause 4 said, Milord, if during the period of short-term settlement, the tea garden is found closed for a period of exceeding 3 months, and or if there be any default in making payments to the workers, their due wages and other benefits, or in case of statutory non-compliance for a period of 2 months, either consecutively or otherwise during the period of short-term settlement, the short-term settlement shall be terminated as per due process with an unfettered right of the state government to resume the tea garden and deal with the same as being deemed fit, the state government finally recorded in writing. So, my lord, this is the unfettered right even given by one SOP. Now, the SOP at point of time was challenged before the, my lord, this coordinate bench of this Honorable High Court, my lord. Matter went in a division bench, it has been affirmed. And my lord, the coordinate bench even directed the matter to be relegated to the, my lord, the Land Reforms Tenancy Tribunal. In view of this, my lord, the Land Reforms Act, my lord, this SOP has come. So, now, as of now, the SOP is tearing at our face. Now, on the strength of that bipartite agreement, they are paying the wages and the benefits to the workers. We are concerned at this juncture, my lord. Kindly appreciate one aspect also. When such, my lord, the case was initiated against Prasanna Rai, when the garden was closed, when such bipartite agreement has taken place, when the workers are being benefited through this, my lord, entity, then they want to stall to receive the benefits to the workers through this entity, my lord. We are, my lord, whatever the attachment, freezing, we don't mind. Either let ED take the responsibility to make payment to the, my lord, the workers, because the the plight of the workers cannot be vulnerable, my lord. Or, my lord, my alternative, my lord, suggestion, my lord, this is only, my lord, as my senior friend even has pointed out, the seizing, freezing, or the attachment, my lord, is the purpose of the out of the sale receipt, whatever, my lord. Let them, this Jimba may be given to this present entity. Let them run. Let them secure this so that the workers can be survived, my lord. This is the, my lord, stance of the government, my lord. And we are contemplating to invoke the SOP for granting the, my lord, the 1 year short-term settlement. We are in the process. This is our stand, my lord.
To him.
Yes. Because, my lord, 1 year, that gestation period, if he pays the throughout without any making any default to all the payments, wages and the statutory dues, then we will process for a short-term settlement for 1 year, then subsequent 1 + 1 + 1. And, my lord, my humble
So as
maybe-
of now, state has not settled it in his favor.
because 1 year, my lord, has to be sealed. Because
He has not completed.
yes,
the-
yes,
No,
my
I
lord.
have, in 2023, Lord, there was a bipartite
But
settlement.
state says.
But-
I have may already
even-
applied. It is for them to take, Lord, pursuant
Lord,
to my application as steps.
My lord, the bipartite agreement may
But
take
1
place.
year is over. After 1 year, I have applied. The application is, Lord, at
No, yes, application
35,
is
36.
there. That's why I said
35-36.
we are contemplating for issuance
That
of,
was,
my lord,
Lord, 20th December 2024. I have applied before, Lord, the state government pursuant to the SOP.
and we are contemplating as they are making payments to that. My lord, we are only concerned, whoever it may be, A, B, C, D, we don't mind. But the plight of the workers to be, my lord, protected. Because there are around 1,500 or 1,400 workers, you know, they are engaged, they are in the this one of the tea garden. My lord. So if, my lord, this situation, my lord, what will happen, my lord? They will leave. Lord, kindly visualize the situation, because what is the object of the state government? The entire tea gardens, my lord, these SOP, my lord, we are constant to enforce this SOP, my lord. Because otherwise, my lord, we are not in a position to, my lord, to invoke this, my lord, if the obtaining a lease for 30 years, taking a financial assistance from the bank by creating a charge, my lord, thereafter they fled away. So this is the reason, and, my lord, very peculiar situation, my lord, when there is, my lord, an off season, my lord, when there are no leaves, they leave. When again the, my lord, these, you know, it is functioning, means I mean that in a peak season, my lord, when they are producing the finished teas, then, my lord, they come and they do not pay the bonuses because they say, so 6 months they did not work. So how you are entitled of that? So this is the reason, my lord, that we have invoked this SOP for the only concern for the workers. And, my lord, the section 60 of the CPC, my lord, agricultural produces, the lordship knows,
Cannot be
it
attached.
cannot be. Even the tools, machinery is under section 60.
Agricultural produce, they have not.
My lord, tools are there in section 60.
Tools and tackles.
That. So tools or tackles falls within that, my lord. So in this
this will override that.
This will, that definitely a special statute, but the object of the, Milord, the intents of the legislature to protect the my agriculturists, my farmers. So this is my situation, Milord. What about the, Milord? I cannot support the Mr. Prasanna Roy. I cannot support this entity. Only I have to support my workers. If the Prasanna Roy had, definitely he should face the consequences. Whatever ED wants to do, let him do. Or ED take the responsibility of the workers. Let our assurance be given that we will take care of the workers. Definitely we don't have any stand.
Mr. Chakravarti, what is your answer to this?
My lord, I am answering.
So
Lord, one
far
by
as,
one.
so far as the question of locus is concerned, you see rule 4 of
And there, my lord.
the big caption rules.
And there, my lord. And there.
This GSR 445E.
Yes. And there, my lord.
Rule 4 says that the authority shall prepare a seizure memo and it shall be delivered to the occupant.
Correct.
From Mr. Mukherjee's submission you have heard.
Correct.
Respond to that.
My lord. May I answer, my lord?
Yes, please.
Yes. My lord, rule 4, 1A, sub-rule 1A, the last part, and a copy of such order shall be served on the person concerned. I think my lord is looking into the rule which has not amended, because this has undergone amendment in 2013.
No. I am looking at rule 4, sub-rule 2.
Sub-rule 2, very well, my lord, including the person in charge of such vessel, vehicle or aircraft. Rule 2 is, sub-rule 2 is relating to vessel, vehicle, aircraft.
No. Shall be delivered to the occupant of the building, vessel, vehicle or aircraft.
Correct. Occupant of the building, vessel, building, place, vessel, aircraft.
So if he is the occupant of the tea garden,
correct.
he has been served.
I've served.
So therefore he has right to challenge.
No, I'm coming to that. I'm coming to that. Milord, occupant, Milord, rule 4 is incommensurate with section 17. If your lordship sees section 17 and rule 4 side by side, your lordship will find that it talks about 17(1)(a), what my learned senior friend Mr. Mukherjee was reading to. Property shall not be transferred or otherwise dealt with. The rule also says that property shall not be transferred or otherwise dealt with.
So why does that not give him a right to challenge? It gives him a right to challenge.
I'm coming to that, Malak. Now
we are presently at that question only.
I am answering that only.
Part later. First this question.
I'm answering to that only. I'm not going into the merit because it was my prayer. Well, the first part, transfer, denotes a restriction upon the owner, because other than owner, nobody can transfer. The second part, otherwise deal with.
Mr. Chakravarti, it has several connotations. An occupant can also transfer the possession.
Yes. Malad, very well.
So there,
I go by that.
The right of the occupant creeps in.
Otherwise, or will not otherwise deal with. So the occupant can otherwise also deal with. So the purpose of section 17 of the corresponding rule 4 specifically thereto is to stop alienation, transfer or otherwise dealing with.
Therefore, he has a right to challenge.
Now coming to that, Miller, I have said.
Because I'm making it easier. Suppose X is in possession of a property. Property does not belong to X.
But we need not to enter into this, Miller, today.
No. I'm making this clear to you so that you can answer it properly. X is in possession of a property. He is only occupying that. He is not the owner of the property. There is a notice, say in the nature of eviction, that has been served on the on the person concerned who can claim say title over the property, say is a lessee.
Correct.
Since he is a sub-lessee, he is in occupation, he has been served with the notice.
Correct.
He has right to challenge that because he is also.
Correct.
He is fine.
Correct. Coming
He
to
is
that,
victim.
coming to
Although
that,
it
Milord,
will be a different thing to say that he'll be bound by the
Original.
lesser's,
lessers,
whatever happens to the lesser.
right. Now, well, that is different. Now, what I am submitting from the submission of state, who basically appeared and submitted like a pro forma respondent, and the petitioner, your lordship will kindly mark two things. Number one, petitioner said that he is in bipartite agreement since 2023. State government came before your lordship and said that they have a SOP. Well, this SOP is of 2024, which has been given to your lordship. So, which is after that arrangement, so-called arrangement. And even state government said that the petitioner showed his application in December 2024 in terms of the SOP. State said we are contemplating that upon him. So as on date, what is the position, Milord? He has not been allotted under the SOP even. As on date.
That has been clarified by the state.
Right.
He has applied.
So it is in contemplation. So he says that I am in occupation. Who is in occupation? By virtue of a bipartite agreement between a company, a private limited company, and a union of tea garden workers.
No, but Mr. Chakraborty,
Why I serve
for the SOP to apply, the condition is that he has to be in occupation and run it for 1 year.
Correct.
He has to be in occupation for some time.
I am not going into those things. We have served.
No, I am only strictly on locus first. I'll move on to the next point.
Correct.
First the locus.
Correct. We have served.
Because if you cross this hurdle, then I need not unnecessarily make myself busy with the other points. I will also be happy.
Let's kindly come to page 31 then.
Page
31 of the writ petition. I pointed it out on the last occasion, last day. Probably it has gone unnoticed. May kindly come to that.
No, I've seen it. Plucking, I remember. It has not gone unnoticed.
Plucking and selling of green leaves.
Yes.
Now what we have attached, kindly now come to the freezing order. Page 90 starts, kindly come to page 92 onwards. Old thorough, new throw, old throw, new throw.
Old troughs, fans, new troughs, motors, monorails.
Oil heater, water pump, single cut, CTC cut machine, CTC my lord, not green leaf. CTC cut machine, single cut, dryer, number 1, number 2, heater number 1, 2, chasing machine, cutter grinder, mixed chamber, spot humidifier, engine pump, siren, irrigation pump. None of these machineries are required. And then your lordship will find CTC to dryer, CTC to dryer, sorting machine, vibro screen, sorting conveyor belt, mini Java, milling machine. And next vehicle details are few vehicles, including Tata truck and Mitsubishi Canton. Thereafter, the bungalow, page 97. 2 bungalows. None of them are required for the purpose even where it is the bipartite agreement. We have not seized or attached or frozen any of the tea bush. We have not attached any of the shade tree. We have not attached any of the green leaf. So his bipartite agreement, even given to the preference at this stage by your lordship, it will be his job to pluck and sell green leaves, for which neither bungalow nor the machineries of CTC is required. His locus is not there. Now coming to the second point, man, how his locus is not there. Man, what I am saying, what I am submitting, that the properties belong to a company. My lord can recollect my POW, page number 10, paragraph number 70. Those properties are owned by two persons, Prasanna Rai and his wife. 50-50% share. Entire property belongs to them. Now, when the entire property belongs to them, the machineries they are the owner. He, by virtue of the state has also said he is managing. State has said that we are only concerned that the wages to the tea workers are paid. Whoever is paying, as per the SOP, we are handing over to it because it is our utmost concern of the agricultural produce. We have not touched the agricultural produce. We have not touched. We have not stopped plucking of green leaves, selling of green leaves. Let him continue plucking and selling of green leaves. Who prevented him? This is number one. Number two, this freezing order today is of no effect. As your lordship has rightly pointed out, even if this freezing order is today set aside or quashed, the order of provisional attachment on those properties, plant machineries.
So, Mr. Chakraborty, do you mean to say that the freezing order has lost effect?
Yes, I am not mean to say, I am saying.
Kindly record that, my lord.
Yes.
I'll not
Record
bother your lordship, my lord, with this. Kindly record that. He should have,
Record
without
that.
wasting time
I am saying
of
from
the court,
first
he should have
moment.
said that the
I
freezing
have
order, my lord,
said
has
that.
now become infructuous and therefore it
I
should
have said
it's
the
not
writ
in
petition
force.
become infructuous because
We should have let our other learned friends to, my lord.
Very well. Then I'm recording that. I'm recording.
Correct. Correct. I have said that. Specifically.
I was
Could have been
educated.
done.
In
I'll
the
give
process
lot-
only I was educated. That's
But,
the benefit.
I have said it specifically.
I'm saved also because
Yeah.
I would have had to devote another hour.
That is why I said that writ petition has become infructuous
It
because
is
after
submitted.
PAO on 21st of June.
Mr. Chakraborty, please correct me if I'm wrong. Please listen to the order.
Bye.
At the outset, it is submitted by Mr. Chakraborty, learned advocate appearing for the respondent numbers 4, 5, and 6, that the writ petition has become infructuous in as much as the order of freezing dated May 30, 2025, Lordship, that has been challenged by way of the instant writ petition has lost force in view of the subsequent order of provisional attachment that has been passed on June 21, 2020.
Kindly name the
25.
gentleman because he is not that, my lord. My client is not, my lord, who is the subject matter of it.
His client is not supposed to be subject matter of this PAO.
So only I request your lordship to record that.
Against whom has this been passed, Mr. Chakraborty?
My lord, you will find that at the end of the 56 pages, if your lordship comes at the last page.
And we have taken, my lord, the excerpt from the register of companies, my lord. They are not the directors of the company. Will not.
My lord, 1 Prasanna Kumar Roy, 2 Kajol
Against-
Soni Roy, 3
against-
Samsung Organic Tea
এই-
Private
এইগুলো
Limited,
copy করেন।
1 to 5.
Against A, again 1, 2, 3, 4, 5.
5.
Against 5. 1, 2, 3, 4, 5. Page 55. Page 55. It is submitted that the said order pertains to the same properties.
Yes,
Mr. Chakraborty, to the same
identical.
properties, to the same properties to which the order of freezing relates, impugned order of freezing relates. Full stop. In view of the aforesaid submission, Mr. Mukherjee, then I'm.
But kindly then set aside not that order of freezing. It
If it
has
has
No,
lost
it,
into
it
this.
cannot be
If it
set
has
aside.
lost force,
It has
But
lost
kindly
its
record
force.
that.
I
That
will
now that
record it.
it has lost its
Ah.
force
It is
and they
recorded.
cannot
Now,
implement that.
since, in view of the aforesaid submission, since the order impugned dated May 30, 2025 has
Superseded
already
by
lost
God the
force and has been superseded by an order of by a provisional attachment order dated June 21, 2025. This writ petition is disposed of as having become infructuous.
Can you
Deeply
record
obliged.
the our stand for a 2 line?
Unnecessary, I'll have to record everybody's stand, then it has become infructuous. Because
May I deeply obliged.
nothing remains. Same thing with the other one also.
Same.
Same,
Same.
identical.
Same.
Identical.
But,
SOP also I'll get back. Or again in the.
Your lordship can retain that SOP.
Yes.
Your lordship may require that, not in my other cases.
But it disposed of fine. Disposed of.
SOP টা ফেরত দিয়ে দিন।
লাগবে পরে লাগবে আমাদের
SOP টা
No, no, my lord will kindly keep the SOP. That will help in other matters
He will,
also.
he will supply me again when I hear it.
My
Or
lord,
whoever
my
hears
lord,
it.
my
Because
lord.
I'll be leaving the circuit on Friday, so somebody
My
else
lord.
will hear it.
No, my lord, the
Deeply
next round of your visit, my lord, this will continue the other matters.
Maybe it is over by the time I come next.
Much obliged.
Deeply
I'm
obliged.
grateful.
Deeply obliged.
হ্যাঁ, অজয়ের বইটা দিয়েছেন।
What happened? You file it, file whatever you have to file, you file. It will appear in due course. It's a pending matter. Pending matter, give it, it will appear in the list. I don't know whether I'll be able to take it because tomorrow is a hearing day. Everybody's, no upgradation. You file it, it will be taken up in the due course. Call karo. Call karo. 2 PM today.
Lord, item 62, Lord, I beg to appear on behalf of the Lord West Bengal
Yes,
Information
yes, yes.
Commission.
Yes, Mr. Saha.
Yes, Lord. My Lord, I beg to appear for the petitioner, my Lord. Am I audible?
Yes, yes. There is a judgment of the Honorable Supreme Court which has been delivered on 7th of February 2025. You can get it online also immediately. Public Information Officer and Registrar versus Onkar Dattatreya Kalmankar.
My Lord, can I get the citation once it will be getting?
I don't have the citation. It's
Perhaps not been reported yet.
no, it's a one paragraph judgment, rather an order. I don't think it's reported.
My Lord, okay. My Lord, which one? Public Information?
Officer and Registrar versus Onkar, O-N-K-A-R, Onkar Dattatreya, D-A-T-T-A-T-R-A-Y.
Public Information Officer Register.
7th of February 2025.
Two-page judgment, my Lord.
Yes. See, I think it supports your case.
Lord, if your Lordship, Lord, kindly allow me to, Lord, place another judgment. Only, my
Yes.
Lord, but at the very outset, my Lord, I must be it clear that I am not tooth and nail supporting my own judgments.
Not a
Only for
problem.
only for the purpose of assisting a Lordship. But I
Yes,
will
yes.
rely certain, my Lord, observations. But if my junior is there, it is 2025 SCC 481. I'm handing it over to your Lordship. I'm just taking my junior. Dada, arekbar bolbe 2025 SCC 481. 481.
Yes, where is the copy? Your junior friend appears to be in problem.
No, my Lord, I believe my junior is yet to reach. My Lord, they are just coming, my Lord.
No, he is there in court. Oh, he's somebody else.
Lord, it's a 5 judges bench judgment, my Lord. Lord, basically, my Lord, it's a here the question involved. Lord, here the appellant was the Public Information Officer of Supreme Court itself. The question involved over here that whether the my Lord, the section 8(1)(j) and section 11 elaborately described over here. What is the scope and, my Lord, the area of these two interconnected sections. My lord, the issue was whether, my lord, the assets of honorable judges and also, my lord, the collegium systems.
Mr. Saha, that would not apply. The judgment which I have just now indicated to you, it relates to disclosure of marks of other candidates in an examination, a public examination.
Right,
Right,
lords.
which is
It
the
more
case
pat on the
here
point.
also. He wants to know the marks of the other candidates in viva voce and in the examination. That is his prayer in the writ petition. Now
Yes,
here
sir.
it says that disclosure of marks, though may fall in the category of personal information, yet such disclosure of personal information is presently necessary in public interest, and therefore it is not an information which cannot be given by the information officer.
Right, lordship.
Yes, yes, my lord.
So, my lord, your
Because
lordships can directly, my lord, direct the SPIO concern to
SPIO.
provide all the information, lord.
SPIO, my lord. SPIO.
The writ petitioner's prayer in the writ petition is to disclose marks.
Yes,
that is
exactly.
prayer. And this also is a public examination. What examination is this?
Yes, my lord. That was conducted by the DM for the
Public
recruitment.
examination, lordship.
Recruitment, yes, my lord. Yes, yes, yes. The qualifications and the academic score of the selected candidates. The 42, my lord, they have written over there categorically.
Lord, prayer A may be allowed. That will suffice the, my lord,
Yes.
the requirement of my learned friend.
Let me see what
By-
the Bombay High Court had done. Yes, the Bombay High Court judgment, which has been upheld by the Supreme Court, pertain to recruitment of post of junior clerk in district court. So almost similar.
My lord, the fact remain is what also I also came through several judgments and the statute itself. The balance of the privacy and the interest, the at a large, public interest at a large. Now, my lord, here the case is, my lord, the interest is required. The public interest is there, my lord.
The writ petitioner Mr. Banerjee, yesterday
Yes, madam.
you had handed up another judgment of, it is not there in the file somehow.
Yes, my lord. My lord, the Arvind Kejriwal or the good
Yes,
governance?
No, Arvind Kejriwal.
My lord, I can cite it, but
You give me the citation.
yes, my lord.
I have a
Just
copy.
Well, that is state of Maharashtra versus Lord Jalgaon Municipal Corporation. One line was Lord.
no. This was
basically-
this. No. This was not. This was.
This Arvind
Yes,
Kejriwal and
Yes, Arvind
Kejriwal.
Kejriwal.
But
Yes, yes,
two judgments were cited by my learned friend.
Yes,
on
and
the
what was the third one?
third one? Well, on the first day, he cited Lord
My lord,
RK Jain.
Arvind Kejriwal.
First day you cited to CBSE and
Yes.
Aditya Bandyopadhyay.
And
My lord,
RK Jain.
Arvind Kejriwal versus Central Public Officer and another.
Yes, this is the third one. Where is the fourth one?
Well, the RK Jain.
RK Jain is there. You have cited total 3 judgments.
Total 4 judgment, my lord.
Which is
Aditya
the Aditya Bandyopadhyay over, RK Jain over, Arvind Kejriwal over. Which is the fourth one?
No, the one I have said no.
Good governance.
Yes, not the state of Maharashtra versus Jalgaon Municipal Corporation.
Yes.
2009 SCC 731.
2009, 2003, 9 SCC 731.
But here under paragraph 35, one line, Lord, he has referred.
Yes.
That is for the good governance.
2003, volume 9 SCC, page?
Yes, my lord.
731, Lord.
73.
31. 731.
731, para 35.
My lord, para 37, my lord.
Para 37. Yes. It has been submitted by Mr. Banerjee, relying on the aforesaid judgments that for the what was your submission?
Lord, my submission is, Lord, the same thing, but has been, Lord, laid down in the 5 judges bench.
That it is personal in nature and therefore it is exempted.
Lord, larger public interest has not been involved over here. It's a single, Lord, one, Lord, the candidate who sought for the information for his own benefit. Larger public interest is not there.
That larger public interest is not involved in the matter in as much as only one candidate has sought for information of others. Full stop. Mr. Saha, you are relying on the reasons given by the commission.
Yes, and also, Lord, I am relying upon, Lord, one judgment, that is 2025 SCC 481, Lord.
Which paragraph? I don't
Lord,
have that judgment.
Lord, paragraph 36, 61, 62, 72, 73, 78, 79, and 80, Lord.
2020? 2025 SCC, your voice, you are inaudible now. Four 81. and submit on his judgment of the Honorable Supreme Court in the case of 2020 within bracket 5 SCC 481, and submitted that only in cases of larger public interest, personal information relating to others can be supplied. Full stop. Paragraph. Learned advocate appearing for the respondent state authorities has handed up to court the instruction
Lordship, am I audible, Lordship?
by the forwarded to him by the district panchayat and rural development officer, Kuch Bihar. Which has only indicates the facts of the case. Full stop. Paragraph. Having heard the learned advocate. The writ petition being WPA 1371 of 2025 is disposed of by directing the respondent information authorities to disclose to the petitioner the marks obtained by the selected candidates in the written examination and in the viva voce for the post of executive assistant within a period of
The direction is upon
the respondent information authorities,
SPIO, State Public Information.
information
Or-
authorities, whoever would.
My lord, kindly respondent number 4, my lord. Otherwise, I
Respondent
also
number
will.
4.
Yes, Lordship, I also believe.
Respondent number 4. Respondent number 4, IE. He is the SPTO.
SPIO.
SPIO, my lord.
IE, the Deputy District Panchayat and Rural Development Officer, A4. Kuch Bihar, being the SPIU, within a period of 6 weeks. 6 weeks. Information of marks.
But 30 days is normal time limit under section
Within a
6
period
of the information.
Within a period of 4 weeks from the date of the petitioner furnishing relevant fees. You may have to furnish the fees for that.
Yes, yes, my lord. Yes, my lord. Yes, yes.
From the date you furnish the fees, within 30 days thereafter, you will get the information.
Yes, my lord. Yes, yes.
Within 30 days from the date the petitioner puts in the requisite fees.
My lord, my lord.
Permission for putting in the requisite fees for obtaining such information under the Right to Information Act, 2005.
My lord, only one indulgence, as my lord directed to furnish the information related to
Marks.
the marks. That
Yes.
my lord, but my lord, kindly take my lord page number 42. There was the qualification, because my lord, that
Your
was
prayer
the.
is marks only.
But my lord, I have challenged the 42.
But your prayer, you see the writ petition, prayer
Yes,
is.
my lord, kindly, just my lord. My lord, kindly give me 1 minute. Yes. Yes, my lord. This is prayer A, but my lord, I have also challenged the final order which was passed in the
That
second
order
chapter.
I'm setting aside. That order I've set aside. And
Yes,
they will give you the marks.
Yes, my lord. But the qualification is also required, my lord.
Very well. The qualification as well as the marks. ওখানে করে দিন, ওপরে যেখানে
Grateful, my lord. Grateful.
qualification as well as the 137 or 25, that they will correct. I said 24.
23.
No, 25 only. 23 বলেছি? 25 বলেছি। No, I said 25. 137 or 2025 allowed.
Grateful, my lord. Grateful. Grateful. As I've indicated also earlier, and today I have came to know about this new judgment, the Omkar Datta Roy. Grateful, my lord. Yes, grateful, my lord. Grateful.
Grateful, Lordship.
Thank you.
Grateful.
না যে একবার বলেছি যখন WPA লিখতে হবে একজন, শেষে ওটা লিখে দিন।
My lord, it is that matter of.
Yes.
I believe my lord has gone through the SOPs.
There is a judgment of the Supreme Court which permits clubbing.
My lords.
So there is a recent judgment of Justice Gawai, 19th May 2025. It is Ravinder Singh Sidhu versus State of Punjab.
till date. This will be a complete set.
No, that is the duty of the police. They will follow the SOP, madam. দিদি পুলিশকে তুই তো দিলি
হ্যাঁ আমি এইটা দিয়ে দিচ্ছি এখান থেকে, এটা আমার মার্ক করা, তোমাকে আমি আনমার্ক
হ্যাঁ
করে
দে
দিচ্ছি। দাদা এখন কি দিয়ে দেবেন এসব কিছু?
Item number 22.
মাইক
Malad, we are led in this matter by Additional Advocate General. He's in court number 1, madam. So kindly the matter may be passed over.
ফার্স্ট
23, Lordship.
My lord, in this matter, we are appearing on behalf of the corporation, Siliguri Municipal Corporation, my
Lordship, I am for the petitioner.
He is leading me, Lordship. He is leading me.
Lordship, here is the affidavit of service. Lordship, hearing this matter, Lordship, the respondent number 5 to 7 are constructing an illegal infrastructure in the land of the petitioner without obtaining proper building plan pass from the Siliguri Municipal Corporation. On that ground, we have made several representation, but that has not been considered yet. I'm praying.
Why are you not taking action? If
My lord, there is no
complaint,
question of
a
taking
complaint
action.
regarding unauthorized construction has been made,
Yes, my lord. Yes, my lord.
why
But
are
my
you
lord,
not taking action?
my lord, may I be allowed to place certain things, my lord, before your lordship, my lord? We are always ready to take actions. We are always ready to consider the representations made by the petitioners. But my lord, kindly come to their paragraph number 6, page number 4, paragraph number 6. There it is stated that the private respondents, they are not private respondents, they are the Sikkim nationalized transport, which comes within the zone of other authorities under the state of Sikkim. They
Very
are
well.
constructing.
Even if an authority is indulging in unauthorized construction, you need to take action even against them also.
My lord, now the question is whether the construction is authorized or unauthorized.
So
That
that
has
you will
to be
decide.
decided, my
So
lord.
you have to decide that. Who will
Yes, my
decide
lord.
that?
Kindly come to their paragraph number 7.
Why are
they
you
have
not taking
printed-
decision? Why are you taking me through several paragraphs? If there is an allegation that construction is unauthorized, you take a decision. If it is not unauthorized, you reject the complaint. If it is authorized, if it is unauthorized, you take steps in accordance with law.
My lord, actually, then let the authority be considering their
Representation. Yes,
And
unnecessarily, why are you arguing?
page number 14, that is the representation which they have made before the Siliguri Municipal Corporation. But let that be considered. But
Yes,
my lord,
that should
I
have
have
been the
been-
first submission. Nearly. Lordship.
Grateful.
The
item number 22 that was passed over. Then at age is, yes, ma'am. 22.
Yes. Yes.
My lord, in this proceeding, two notices issued by the BLRO and the DLRO respectively are under challenge. My lord. Now, my lord, the background of this case is in the year of 2020, my lord, a tea garden was leased out to this petitioner company by the government of West Bengal. Now, my lord, very interestingly, kindly takes up the lease agreement, my lord, at page 20.
Page 20.
Page 20 of my petition, my lord. My lord, we'll see the heading itself. It says lease for tea garden retained under subsection 1, read with subsection 3 of section 6 of the West Bengal Estate Acquisition Act. So, my lord, admittedly, this tea garden has been indicated to have been retained by the petitioner company under section 6(3) of the Estate Acquisition Act. Now, my lord, this petitioner has been running the tea garden, managing its affairs through the period of time. Suddenly, my lord, on 16th of April 25, my lord, will find the notice at page 80, my lord.
Yes.
Page 8080. Suddenly, my lord, in the month of April 25, the office of the BLRO, respective BLRO, Fashidawa, issues a notice to me stating seeking NOC for resumption of land in favor of the collector's Khotian. So, my lord, it says, in accordance with the aforesaid subject and reference, the undersigned would like to inform that as per the objective of scheme for
Which page are you reading? 18 is lease agreement.
my lord, page 80. 80.
80. Yes.
80 is the first notice issued by the office of the BLRO to me. It says, my lord, I'll read the operative part. In accordance with the aforesaid subject and reference, the undersigned would like to inform you that as per the objective of scheme for redistributing homestead pattas among landless tea garden laborers in West Bengal, it is necessary to seek NOC from the concerned tea garden for resumption of unused land of tea garden permitted to retain under section 6(3) of the West Bengal Acquisition Act, Estate Acquisition Act. So, my lord, after that, it specifies certain plots of land altogether measuring 19.13 acres. So, my lord, this notice itself is vitiated by law, which is section 6(3) of the Act itself. That is my first round. Now, my lord, kindly takes up section 6(3). I have reproduced it in the petition itself. Kindly takes up, my lord, paragraph 8 of my petition.
Paragraph 8.
Yes, my lord.
Yes.
This is the reproduction of section 6(3). It says, in the case of land comprised in a tea garden, mill, factory, or workshop on the intermediary, where the land is held under a lease, the lessee shall be entitled to retain only so much of land as in the opinion of the state government is required for the tea garden, mill, factory, or workshop, as the case may be, and a person holding under to be an intermediary. So, my lord, admittedly, under this section, this entire 844 acres, which was leased out to me, was permitted to be retained by me under the provisions of this Act. A formal lease agreement, my lord, in the year of 2020 was executed with regard to that same parcel of land. My lord, the proviso is very important. Proviso says, provided the state government may, if it thinks fit, so to do, after reviewing the circumstances of a case and after giving the intermediary or the lessee, as the case may be, an opportunity of being heard, revise any order made by it under this subsection specifying the land which the intermediary or the lessee shall be entitled to retain as being required by him for the tea garden. It essentially says that after reviewing the circumstances, giving an opportunity of being heard, and after thereafter passing a reasoned order, it may revise the original order under which it permitted me to retain this particular parcel of land. So, there are essentially three postulates. First is the review of the circumstances, which essentially means that you have to
comes under the proviso.
Yes, my lord. Only under this proviso can this original order, which was made under 6.3, can be revised. But the revision has to go through a detailed process, which is reviewing the circumstances, giving an opportunity of being heard, and my lord, thereafter passing a reasoned order by which the original order can be revised. These three are the postulates which have to be gone through before passing any order. Now, my lord, the act on their part of seeking an NOC from me itself implies that this proviso is not applicable, because my lord takes up thereafter. This act came to be amended in the year of 2020. My lord, has the Estate Acquisition Act. Yes.
My lord, you can, my book, I can hand over my.
Yes. Kindly takes up section 6.3 proviso explanation number 2. Explanation number 2 following the proviso.
Proviso, explanation,
Number 2.
acquisition land.
Lord, section 6.3 of the Estate Acquisition.
6.3.
After that, my lord, 6.3 will contain a explanation 2. It says, my lord, this was amended in the year of 2009. It says, for the removal of doubts, it is hereby declared that the expression revise any order mentioned in the proviso to this subsection shall, notwithstanding anything contained in any law for the time being in force, or in any agreement or in any decree, judgment, decision, award of any court, tribunal, or authority, include revision of an order of retention made under this subsection at any time after the order of retention so made, if the intermediary or lessee, as the case may be, fails to use or ceases to use the whole or any part of the land for the purpose of which it has been retained, that is for tea garden, mill factory, workshop, etc. So, my lord, firstly, they have to go through that entire process that I just mentioned, reviewing the circumstances, opportunity of being heard, passing a reasoned order. Secondly, the basis on which this revision can be made is provided in this explanation, my lord. The explanation says that if I cease to use this particular plot of land as a tea garden, mill, factory, etc., only on that subjective satisfaction can the state government seek resumption of this said land. Now, my lord, kindly, in the same breath, kindly sees the notice issued. The notice says, you give me an NOC for resumption of the land. So, my lord, no objection certificate by itself implies that I am using that land for that purpose, which is why they are seeking an NOC. They're not seeking resumption of the land. They're not saying that I have ceased to use this 19 acres as a tea garden, mill, factory, or workshop, which is why they are seeking resumption. They are seeking an NOC instead. So, my lord, by these reasons, these notices, the first notice on 16th of April 25, thereafter the same notice was reiterated by the DLRO, 24/4/25, my lord, at page 82.
Page 82.
82. 80 is the first notice by the BLRO. 82 is the second notice, reiterating the first notice by the DLRO. Yes, my lord. 82 is the second notice by the DLRO, reiterating the contents of the earlier notice. It also seeks an NOC from me for resumption of the land. So, my lord, these two notices are violative of section 6.3, the proviso, as well as the explanation inserted by the 2009.
Same authority.
No, my lord.
80 is also by the BLRO.
I'm sorry, my lord. That is the notice. 81 kindly comes. 81.
81 is DLRO.
Yes, 81 is the forwarding by the DLRO of the same notice which was issued earlier by the
It is
BLRO.
the same.
Yes, my lord. So he issues the same notice again on 24th of April 25. So, my lord, I'm going back again to the provisions of law. 6.3 proviso explanation. These two notices are violative of that. My lord, I'll just place one judgment of the Honorable Supreme Court in this regard. Another point which is very important, my lord. This is to citation reported in, my lord, 2009, volume 4, SCC 453. My lord, para 25. Para 25 of this judgment. 453. Para 24 of this judgment is important.
24.
24. Lord, reads 23 first. It says, in our opinion, the correct interpretation of the said proviso is that once an order is passed by the state government under section 6.3 of the 1953 Act, thereafter the power under the proviso to 6.3 of the Act can be exercised only if some fraud or misrepresentation was made to the state government for obtaining the order under 6.3 of the 1953 Act, or where there was a genuine and important mistake by the state government in passing the order under section 6.3 of the 1953 Act. However, in our opinion, the power under the proviso of 6.3 cannot be exercised on the ground that after the order of the state government was passed under the main part of section 6.3 of the 1953 Act, some subsequent developments have taken place. So, my lord, on the basis of subsequent developments, they cannot issue this resumption notice. They have to say that at the time of issuing the original retention order, there was some fraud or misrepresentation on my part, or there was some genuine mistake on the part of the state government in issuing the original retention order. Takes up, my lord, para 24 thereafter.
Just.
Yes.
Yeah.
Para 24 thereafter, it says, to explain this, it provides the reasoning as to why this is essential. To explain this, we may clarify that there may be cases where an order under the main part of section 6.3 of the 1953 Act was obtained by the intermediary or lessee by misrepresentation or fraud, example by stating that he has a tea garden, mill factory or workshop, although he has none, or that the land he requires for the above purpose is more than what he actually required. There may also be cases where the state government has, in exercising the power, made an honest mistake. In our opinion, in such a case, the power under the proviso to 6.3 of the 1953 Act can be validly exercised by the state government. However, the power under the proviso to section 6.3 cannot be validly exercised on the ground that some subsequent developments have taken place after the order under the main part of section 6.3 of the 1953 Act was passed by the state government. These are my submissions in crux, my lord, on these twofold grounds, and also this notice is being
So your
violative.
submission, the crux of your submission is that this notice could not have been issued unless there was an indication or rather a satisfaction on the part of the state authorities that something in the nature of fraud or something in the nature of a misstatement
Firstly.
was committed by you.
Yes.
It is only then that they could have invoked the provision for section
6.3,
proviso
my lord.
to revise the order
Yes.
of grant. In your
Yes. Yes, that is one. And also, if they had to come to that satisfaction, they had to go through that entire process, which is review, opportunity of being heard, reasoned order. Review essentially means a survey in my presence and in presence of all the necessary parties, under which they have to come to that subjective satisfaction.
Suppose if you don't give this no objection, what will happen?
Lord, if this is hanging on my head, my lord.
Now, I have asked for a no objection.
Yes.
Does this have any penal consequence? I don't give.
No,
a
my
no
lord.
objection. What happens?
My lord, this does not have any penal consequence, but this will come to my my lord instance again and again if I don't challenge this, because
Have penal consequence or an adverse consequence?
no, my lord.
I am, let me use a a word of a lesser degree.
Yes,
Let
ma'am.
me say adverse. Or
Yes.
civil consequence, a much lesser degree.
Yes.
If it does not even have a civil consequence,
Yes.
then would this notice be justiciable?
My lord, that is my exact point. Because this,
Would
if
this give you a cause of action to challenge? For example, I ask you to give a no objection.
yes, my lord.
It is well within your right to give a no objection or refuse to give a no objection.
Yes.
Now, unless you show that your refusal to give a no objection will visit you with civil consequences or evil consequences,
My lord.
would you get a right to be aggrieved?
My lord,
Would you be aggrieved?
I get a right to be aggrieved because seeking this no objection itself is violative of these sections, because
Seeking this no objection underlines the thing that they that they appreciate that you have something within your control to which you can object.
yes. Certainly, sir. Yes,
It should-
yes, my lord.
Because when will I seek no objection? I will seek no objection only if I feel that there is something over which you have right, I don't have.
Yes, my lord.
Therefore, do you give no objection to do that? If you don't give no objection, then I'll be doing something which I don't have the right to do.
Yes,
So if you
certainly.
deny that, what will happen?
My lord, then grants me that liberty, my lord. I'll respond to the.
It's an intimation. No objection is an intimation. But kindly see the benevolent object of the state. My lord, may I hand over a report for my own consumption for your lordship's perusal?
No, Mr. Additional Advocate General, I wanted to just understand this. Suppose he does not give the no objection which you have asked for. What will happen?
We will invoke.
You will invoke 6(3). Then you will review, give him a hearing, you will go through that procedure, or you will.
My lord, this is the government is the, my lord, the owner of the land. For a certain terms and condition, the lease was granted. Now, this is the purpose, what the resumption was sought for the owned worker or the laborer for the tea garden. So that the patta, the landless workers or the tea garden, those they do not have the land, patta can be issued, which the tea garden do not uses the land for their purposes, which originally the lease was granted. And when the scheme was floated, notification was issued and SOP was also been invoked. For this part,
But would it mean that if he does not give no objection, merely because of his non-giving no objection, he will suddenly resume it? He will have to go through the procedure.
yes, definitely, definitely,
Procedure has to be gone through.
yes,
So I can dispose this of observing that.
Yes, my lord.
yes, my lord,
Certainly.
because
In case the petitioner does not give no objection, then the state government will be obliged to follow the procedure mentioned in subsection 3 of section 6.
yes, my lord, we'll then definitely, that will be a more penal and consequential effect, my lord. That will be more penal and consequential effect.
Lord, let-
If he chooses to do, let him do.
Yes, my lord, I'm agreeable to that. Let
It's
them
not-
follow
it's
the
not only
procedure.
This garden, that's true. This is our entire, my lord, not only particular this garden.
No, of course.
Kindly see the ones have a look, my lord, the notification, which I have handed over. The purpose would be very clear.
Yes.
This, my lord, the 1st August 23 notification, my lord. The heading is that, my lord, the scheme for distributing homestead pattas among landless tea garden laborers in North Bengal. The heading is that, my lord.
Yes.
Lordship, sir. Yes, sir. This is the scheme, Lordship got it, heading. Now, this is the scheme floated and notification has come. Then, my lord, the design of objective of the scheme, your Lordship can see. The government has been contemplating to resolve the age-old problem of the landless tea garden laborer by distributing homestead pattas among the such landless tea garden laborers in the district of North Bengal over the unutilized surplus land of the tea garden. That is there in the, my lord, the lease. It is already mentioned. Now, my lord, kindly come. For implementation of the scheme, the unutilized surplus land of the tea garden, which was allowed to be retained by the said tea gardens under section 6(3), may be resumed and distributed among the eligible. So we'll resume. Then, my lord, design of this scheme. B. The DM and collector of Darjeeling, Jalpaiguri, Kalimpong, Alipurduar, Kuchbihar, Uttar Dinajpur will conduct survey. Then proposal of resumption of the unutilized surplus land of the tea garden will be sent to the DM collector.
This also is unutilized surplus.
Yes, my lord.
It is
That
not-
how it is coming. Then, my lord, my notification goes. Then come to SOP. Page 7. একটু start করতে বলো।
7.
Yes, my lord. This is the SOP, my lord. The SOP was scheme for distribution homestead patta, my lord. Section 6(3). Then, my lord, the notification has come. Next page 8. Page 8 next. All the collector was directed, my lord. You are requested to furnish tea garden wise resumption proposal on the basis of aforesaid survey report of the department in the usual manner. Last line. So survey was conducted. Then
No notice was received by
Just a
us.
second, just a
Yes.
second, brother.
Yes, sir.
Then, my lord, next page kindly come 9. Notices were given. Lordship got it. Notices to the chairman, Darjeeling Tea Association, chairman, Terai Indian Plantation, chairman, Indian Tea Plantation, to the secretary, Darjeeling Indian Tea Association, with regards to the entire tea garden, my lord, land-based tea garden. My lord, we did not, as of now, we did not face any single, my lord, objection with regards to this, my lord, any garden. We should the patta even. My lord, it is not a question that they are using the land for the purpose of the tea bushes or the tea gardens. The land which is surplus. And my lord, the corner of the, my lord, at the end of the corner of the earmarked area, which is not being used or cannot be utilized for the said purposes, that we are seeking for a resumption under 6.3. Survey was conducted and this has been identified. The first one, may I, very important matter in court. I understand my junior will lead thereafter. Otherwise, I'll miss that. Sorry, Milord, my or Milord, take it to tomorrow, Milord.
Milord can dispose this off, Milord.
I'll take it tomorrow.
Well,
to be
grateful,
finished.
Milord, grateful.
I'll come back and
dispose of.
Yes.
Dispose of.
Yes.
May I continue, Milord?
Yes, please finish it.
The corner part of the
एड्रेस सारी चीजें सुधार
page 7. No? The Milord, kindly see the identification or demarcation of land. The SOPs was invoked, district magistrate shall conduct survey to identify surplus unutilized land of tea garden. Such land should not, as far as possible, in the midst of the tea garden. preferably at any corner of the tea garden. And if your lordship
Mr. Chaudhary,
Milord.
the person himself says, yes, I don't have any objection, then in that case,
Yes.
exercise under 6.3 may not be taken.
Yes.
If in case the person refuses, I will resort to the
Yes.
procedure mentioned in section
My lord.
6.
Yes.
That is the purpose.
Yes.
Yes.
That is what I feel.
Yes,
Yes,
exactly.
PC.
And this is the purpose, Milord, where the unutilized land.
Yes, I understand.
No, that is
The
what we are saying.
unutilized land, even 60.
Our case is that this land does not remain unutilized because
Very well. In that case,
Yes,
if you don't give no objection and they resort to 6.3, if you have any grievance, you can again come up.
my lord. Kindly
we decide then
sets
further.
aside these notices, my lord.
No, this notice does
No.
not require to be set aside. You don't give your no objection if you are not willing to.
My lord.
If you are not willing to give no objection, don't give no
If
objection.
he chooses not to, then we will resume. That we are saying.
Then they will resume it in accordance with law
Yeah.
by resorting to section
6
6.3.
3.
Thank you.
Time for the petitioner. My lord, I am a owner of a my lord, commercial vehicle. My lord, on 19th of February 2025, my lord, I was supposed to deliver few wooden furniture at a my lord, marriage ceremony. On the way to my destination, my lord, the respondent authority, the respondent number 3, his officials, my lord, restrains my way. My lord, they asked me to show, my lord, the furnitures, my lord, documents and my lord, vehicle documents. I bona fidely, my lord, produced each and every documents. My lord, thereafter, my lord, I was asked to produce the vehicle along with the wooden furniture to the office premises of the respondent number 3. Accordingly, my lord, my vehicle along with the wooden furniture was, my lord, taken to the, my lord, the office premises. And from that period, my lord, the vehicle as well as the furniture has been, my lord, seized without having, my lord, any seizure list, any confiscation notice. My lord, thereafter, my lord, relentlessly, I made, my lord, several representations.
By whom?
My lord, the respondent number 3, that is, my lord, the authorized officer
Of
of, my lord, the forest department. Divisional Forest Officer, Jalpaiguri Wildlife Division.
There is no provision for appeal.
My lord, so far, my lord, the Forest Act is concerned, my lord. My lord, no notice, no seizure list, nothing has been, my lord, served to me. My lord, after, my lord, as and when, my lord, I served several, my lord, representation, my lord, they were constrained to, my lord, serve a notice that a hearing will be conducted on such a date. A hearing notice was, my lord, served to me. My lord, I bona fidely participated in that hearing, my lord. My lord, even after that, my lord, no reasoned order, nothing has been, my lord, supplied to me. The wooden furniture along with the vehicle is still lying in their custody.
My lord, on 20th March 2025, notice was issued for initiation of 59C of the, my lord, the West Bengal Forest, Indian Forest Act, my lord. Then, my lord, lastly on 26 June 2025, my lord, the notice was issued fixing 7 July 2025 at 2:30 p.m. 7 July, last Monday. Yes, my lord, last Monday. My lord, that I do not know what happened in 7 July 2025. This is the status of the confiscation proceeding has been initiated.
My lord, kindly come to,
premature writ application.
my lord, kindly come to page 19. Page 19, my lord.
Why are you not participating in the hearing? Get it finished.
My lord, I have participated, my lord. As soon as, my lord, I get the, my lord, page 28, my lord, that is the notice of hearing. I bona fidely participated on the scheduled date, that is on
7 July. Have you participated?
on 3rd of, my lord, April 2025.
7 July, 7 July. 7 July, have you participated?
My lord, no notice has been, my lord, served to me, my lord, with regard to the hearing of 7 July. And nothing has been, my lord, my lord.
That means there is a proceeding underway. So what should the writ court do now? What will I do?
My lord, kindly have a look on page 19. Page 19, my lord, for my satisfaction.
To the authorized officer.
Page 19.
Page 19, page 19 and 20. My lord, this is the no objection certificate, my lord, that has obtained by lord, my lord.
19 is the tax invoice.
And thereafter, my lord, page 20.
Yes.
That is, my lord, the no objection certificate that has been, my lord, issued by the range officer with regard to that, my lord, the wooden furniture that the forest produced. My lord, I have showed it, my lord, in the course of my, my lord, hearing, my lord. No reasoned order has been passed.
How the writ court will intervene now?
My lord,
My
may I suggest?
My lord,
May I suggest? Today, my lord, we are 9. Today, we are 9. Within, my lord, of 1 month, we will dispose of the confiscation procedure.
To participate in the hearing.
Participate in the meeting.
my lord, I participated in the hearing, my lord. Even, my
now.
It is a premature application.
You cannot usurp somebody's jurisdiction and start passing orders, right? If you have approached if the authorities have initiated some proceeding and you are participating in the hearing there, suddenly in the meantime, a writ proceeding, I will usurp jurisdiction of the officer, pass certain orders. That is
my lord, the thing is that, my lord, if, my lord, the Forest Act is invoked, section 59D.
has been
Yes, my lord. So that has to be, my lord, informed to me, my lord. Because by virtue of section 59D, my lord, my lord, appeal is before the district judge. Nothing has been informed to me, my lord.
Page 28, you have annex page.
He has appeared to.
It is issued by the divisional forest officer. He does not have authority beyond the forest act.
Even, my lord,
Not act
wait,
Under the police act. Will
my
act
lord,
under-
I have participated in the hearing procedure. That is true, my lord. I have showed, my lord, as because, my lord, so if the forest act is invoked, my lord, with,
Can direct the early conclusion of this proceeding.
my lord, let.
That I'm saying, unnecessary wasting of time. From the communication of the order, no? From the
Communication of, yes.
Hmm. Thank you.
25.
Okay.
25 after.
I was directed to file supplementary evidence first. And submit supplementary evidence. And I have also directed to have an evidence service and service the affected. Lordship, so far the supplementary evidence matter is concerned, there is a specific statement from the
পঞ্চায়েতের হয়ে না।
respondent authority.
পঞ্চায়েতের মেম্বারদের হয়, পঞ্চায়েতের প্রধান না।
That the, I am the contractor, petitioner is a contractor, government or contractor, and he was awarded by a contract by participating in a contract tender process that has been page number 90. P2.
Your Lordship,
Lordship.
I am appearing for 2, 3, 8, 9 and 10, the respondents, Your Lordship, but I have not been received the Vakalatnama yet, Your Lordship. If Your Lordship kindly pleases to fix this matter tomorrow, then I can get prepared, and we have not been served with the copy
Not
of the
today.
supplementary affidavit as well.
Supplementary affidavit not served.
Even the state did not get any supplementary.
State.
Oh, November. I did not get.
Add party because the person who has given us the supplementary affidavit, they are the Panchayat Shamiti.
The member of Panchayat.
Member.
The Panchayat committee, absolutely, they have to receive my letter, whatever.
Who do you want to add as? Panchayat Samiti is not a party.
No, Lordship.
But because of the Panchayat Samiti.
As prayed for, leave is granted to the petitioner to add.
On the page.
Matter pertains to whether non-disbursement of compensation regard to acquisition of land by the
Land.
national highway authority. Representation may be
Considered.
Page 20, that is the demand notice has been served on the building. That's.
My lord, the acquisition notice have not been annexed in this case, my lord.
To consider, he wants consideration of representation.
Page 20.
Page 20. You consider and dispose of.
My lord.
This is one order for which everybody is happy. Including the.
My lord, my lord.
The petitioner
Yes,
It
my
will
lord.
gonna be-
It would be, my lord, respondent number 3,
Not two.
not 2.
बस তাহলে ওই land acquisition collector
minute.
বাদ দিয়ে project নাকি একটা আছে রেসপন্ডেন্ট নাম্বার 3 যা আছে ওটা লিখেছে সব জায়গায় তাই
3.
ঠিক আছে যেখানে 2 আছে সেখানে 3 হয়ে যাবে তার নামটা
I'm grateful.
Lords, I am for the petitioner. This matter was taken up by my lordship. And my lords, I also said, this is before my lordship, that if I find something more on the subject, not, then I will come back before my lordship. I have another order that has been passed. I would be candid, notes, although it is an ex parte order, but still, notes, the court has gone into the issue and it has decided it in favor of the petitioner herein. The analogy, my lords, that has been drawn by the court, my lords will find it from page 2 and 3. একটাই আছে, দেখুন না। Lords will record in my case, Lords, I completed in 2008. Herein, somebody who completed in 2011 was also granted the benefit.
what happened to this for this appealed against or
No, Lords, I couldn't figure out any appeal over the portal of the High Court.
it's a fairly recent order so
Yes, my lords, that may be a reason. That may be a reason, but no appeal has been preferred till date. Let the same order be passed, not they will go in appeal.
actually I don't have that
View.
that interpretation
I also understand that, my lordship.
When
because
appointment list.
I was having a different interpretation, but after I heard my lordship, suddenly a spark clicked in my mind also.
even I was with you while I was reading,
lordship,
but
my lordship,
when
my
I
lordship.
went through it, I found that no, it
Or maybe my lords may kindly keep it before the next circuit bench. Till that time, my lords, if the appeal is there, then we will see what happens. Let it go to the next circuit.
aspirate for
My lord, I'm praying for a nod today. My learned senior is engaged in court 1.
what is the
I'm
matter?
representing bank. My lord, it's a proceeding under section 13(2) of the SURFACE Act. We are the
What is
bank.
it? This can be disposed of. What is the problem?
My lord, I am for, we are for the state.
State is the respondent.
How to?
No, state is the respondent. District
My lord,
magistrate.
there is no, the dispute is between, mainly between this Raj.
Prayer is for disposal of application.
Yes, my lord, but on the last
Yes.
occasion, my lord, the respondent number 3 and 4,
They have no right of audience before the DM under section 14.
on the last occasion, they were
That is
to
a
submit
proceeding.
something, some report or something of
Not
that kind.
required, not required.
And
Then, my lord,
DM
kindly
had
pass.
fixed 3 times and had failed to dispose of the
Borrowers have
application,
different
however.
rights. It is settled up to Supreme Court now. Borrower has no right of audience before the section 14 court. I mean, say district magistrate.
We have no objection, my lord.
Yes, you.
It was the objection was raised by the respondent number 3 and 4 on the last occasion.
Then my lord kindly keeps it as a passover.
Disposing this off.
My lord, I do not have instructions from my learned senior.
Your petition I am allowing.
Are you are, it is in your favor only.
I understand. I do understand that.
Students are represented.
Yes, my lord.
Everybody is there.
Yes, my lord.
Good.
Dispose of.
2 and 3 আছে 2 and 3 কেন হ্যাঁ ঠিক আছে Yes, my lord, this is for the private respondent and we are for the state.
And I'm for the bank.
petitioner,
my lord.
Oh.
Being a secured creditor under the, being a secured
Deeply obliged. On the first position only I stated that let the direction be passed. But my lord was pleased to give them time to seek instruction.
very well.
Okay.
I am for the petitioner, my lord, the service and supplementary evidence.
Yes.
My lord, matter about my lord, consideration of representation dated 18 June 2025 about cancellation of permit of some vehicles, my lord. That is my prayer. My lord, kindly some supplementary affidavit, my lord. Page 7 of my supplementary affidavit.
Page 7.
Supplementary affidavit,
Your
my lord.
supplementary affidavit. Page
Dated
7.
6/3/2024.
Yes.
My lord, that offer letter has been issued by the respondent number 3 to the petitioner for carrying student to school. Accordingly, my lord, thereafter, my lord, page 8. Petitioner has
Thereafter, there is no pagination.
page 8, my lord. Then
There
next
is
page,
no pagination.
my lord, top right side bottom.
No, it's
top of-
not there. Blank.
My lord,
Because in my copy, the pagination is there, surprising.
No, not a problem.
my lord, that is dated 8 March 2024.
Yes.
My lord, thereafter, my lord, petitioner has submitted application for permit before the respondent number 2. My lord, on that basis, my lord, next page, page 9, my lord, dated 11th March 2024. Bottom, my lord, date has mentioned in bottom 11th March 2024. On that basis, my lord, the respondent number 2 issued offer letter to the petitioner. Then, my lord, page 10, my lord, dated 11th March 2024, bottom portion mentioned, my lord, the issued acknowledgement of permit application to the petitioner by the respondent number 2. Thereafter, my lord, page 11, 9th April 2024. Permit has been issued by the respondent number 2 to the petitioner. And by registering the vehicle number WB63B6692. Accordingly, my lord, and mention in that permit, purpose of the vehicle for carrying students and staffs of St. Xavier's Public School. My lord, accordingly, my vehicle has been engaged for carrying student of that school. Thereafter, my lord, page 13, dated 1st July 2024.
Yes.
The school authority informed to the respondent number 2 that this is for your kind information that Mr. Subroto Kundu, that is the husband of the petitioner, Subroto Kundu, bus manager of St. Xavier's Public School, will represent any kind of bus related issues or meeting on behalf of our school. Accordingly, my husband and engaged as manager of that school. Then, my lord, page 14, dated 24 August 2024. After satisfied, my lord, kindly last portion, which upon providing the seamless service at a satisfactory level.
Which page? Which page?
My lord, page 14, my lord, dated 24 August 2024, my lord.
This is a
24 August.
Okay.
24 August 2024, my lord.
Yes.
My lord, providing the seamless service at the satisfactory level, last 2 line, my lord, determined by a mutual and consequential agreement in all possibility might get extended for next 6 years. My bus has been carrying student for next 6 years, approved by the school respondent number 3. My lord, thereafter, my lord, representation dated 5 February 2025. Next page, my lord, page 15. My lord, I have representation before the respondent number 2 for, my lord, cancellation of some vehicles who are plying student of that school without legal permit and or valid permit. That is my first representation, 5 February 2025. Thereafter, my lord, next page, dated 8 February 2025. This letter has issued by the respondent number 3, the school authority, to the petitioner for obtaining a meeting for discussion about the academic session year 25-26. I also meet and attend the meeting about this discussion. Thereafter, my lord, after discussion, no order or no decision has not been communicated to the petitioner. Thereafter, I prefer writ application. Next page, my lord, on 1st April 2025 before this honorable court. Thereafter, my lord, page 19, dated 16/5/2025. Respondent number 3, school authority, termination my bus. 15th, after filing writ petition. On 16/5/2025, issued a letter mentioning that termination my vehicle agreement. On that basis, my lord, again, thereafter, my lord, on 17th June 2025, that writ petition number WPA 9691/2025, I have been withdrawn at liberty to file a fresh. That is the order, my lord. Thereafter, my lord, next page, page 23, 18/6/2025. Again, I have been submitted representation before the respondent number 2 for considering my representation by cancellation of permit of some vehicles who are plying student, carrying student of that school. That is my prayer, my lord. Till now, the respondent number 2 not consider my representation dated 18/6/2025. That's why, my lord, thereafter I prefer before this honorable court this writ petition, my lord. That is my prayer.
Yes.
I can have my lordship for a moment. On the very first paragraph, my lords, this supplementary affidavit has been entered by one Subrato Kundu in a case titled as Devapriya Kuhosh Kundu. This Subrato Kundu, my lords, himself preferred a writ petition before. That writ petition, a similar order was passed as is there in page 22. The Honorable Court was of the opinion that writ petition might not lie. The correct remedy for the petitioner would be to approach a civil court. If I can have my lordship on the first paragraph of the order that was passed, it does not give him liberty to prefer writ petition again. It says, learned counsel for the petitioner seeks to withdraw the present writ petition with liberty to pursue her remedies as available in law. Our contention, my lords, is that as a private educational institution, unaided private educational institution, who do we hire as a bus vendor or who do we terminate as a bus vendor? My lords, the writ court probably will not go into it. In all his allegations, there is no public element that is involved.
But if he has made a representation before the regional transport authority, why will the transport?
Yes, why would the transport authority not consider it? Because of two reasons. One is, my lords, that his services has been terminated.
Transport authority can still communicate the decision.
The problem, my lords, would be three. First problem, my lords, would be that in the last paragraph, page 24, his representation. Supplementary. In view of the facts and circumstances, I am submitting the instance representation before you, good office, for cancellation of permit of such and such and such. Otherwise, I will suffer irreparable financial loss and damages as well as loss injury. So as if not, the RTO will act as an agent of the state to remedy his personal loss and injuries that he might suffer.
What does he want? He wants cancellation, isn't it?
Cancellation of permits of certain vehicle that has been written here.
Not cancel that.
Herein, my lords, two of the vehicle are actually motorcycles.
Well, I have the report.
Actually, he should be correct with the vehicle number. What will the RTO consider in this?
Well,
These are not school buses.
my lord, that is my mistake.
Mistake,
My-
supplementary
my
has
lord-
been filed,
my
still
lord,
mistake is
except
there.
there are
Before
number
also
of
writ
vehicle.
petition filed.
There are number of vehicle,
But
except
where is the
to,
cause of action, Mr.
Private
Raj?
dispute, he is
Where
asking the
cause of
writ
action?
court to.
If the school with whom you were having a contract, that school itself has annulled the contract, then in that case, the very basis of your flying the buses for the school goes
Away.
If you don't have any basis on which you will fly the bus,
What is your locus then?
where is your
It is not a PIL.
or cancellation of somebody's permit for your benefit? Why?
And that to motorcycles.
My-
One is a tractor, two are motorcycles.
that is my mistake, my lord, two motorcycle mentioned in my representation. But my lord, if the school has been satisfied for next 6 years to apply, to carry, to.
The remedy would be by way of a PIL.
School you go, because the school has illegal.
He has suffered loss,
My
maybe.
number of criminal case has been lodged against the school authority.
But that's
That
it,
is
that's
going
your
on.
remedy, that's
But,
your
my
remedy.
lord, in this petition, my grievance is cancellation of some vehicle who are flying illegally without valid permit. That is my prayer in that writ petition.
If somebody is
Report does not say so, that they're applying for it.
And
the
he
number that
needs
you
to have
given,
he needs to
one
have a
is about-
locus.
One is a vehicle which is flying from Kuch Bihar to Tufan to Rampur, Jorai. Another is students and staffs of Kuch Bihar Government Model Madrasa School. Third is a motorcycle. Fourth is is one for which bus permit has not been issued.
That is a tractor trolley. That is a tractor trolley. What do we do? This is not a PIL.
Kindly consider my representation. The
What
authority is
representation will be considered?
Cannot be considered because you have said bus. The report says something else.
My lord, there is
You
number of
indicate
bus,
this
my
to
lord.
him by way of a reply to his representation.
Yes, my lord, that should be.
A copy of that can be given to him. He will find his remedy in a PIL or wherever he wants.
You hand over a copy of this. to him.
We will do that.
That will serve your purpose.
And our objection will always remain is there is no public law element involved. The locus is under challenge. in the order, my lords, there would be two corrections. Instead of 692, in other case, my lord, the writ petition number would be 691, and instead of herself, it will be himself.
A copy of the report, my lord.
Please hand.
I am deeply obliged.
Next, call next.
My lord, 30. My lord.
Affidavit of survey, এটা নিয়ে নিন তো একটু
Same order.
ওখানে এক জায়গায় যেখানে একটা অর্ডার ডেটেড 17/6 ওই অ্যাফিডেভিট সাপ্লিমেন্টারি অ্যাফিডেভিটটা দিন ওইটাতে একটা অর্ডার ডেটেড 16 জুন এটা বলেছি
দেওয়া আছে দিয়েছে কপি দিয়েছে
where is your instruction in this
same instruction
Almost same instruction.
very good which page is the order here
My lord, in that it is the first time before your lordship, my lord. This petition first time before your lordship.
so in this petition
No, in this petition, my lords, at the first page, he says Subrata Kundu,
And that is the authorized.
authorized representative, and this Subrata Kundu, my lords, have filed a previous writ petition.
Another.
Are Baba,
They may differ. That is not.
which was dismissed on same.
That is
This has
another.
withdrawn to pursue other remedy.
Petitioner is my lord Sonamoni Ghosh.
All three are same.
This petition is authorized by, affirmed by Subrata Kundu.
ওই যেখানে his submission I am referring এখানে 17 জুন যেটা লিখেছেন ওটাতে এই অর্ডার রেকর্ড করবে এই WPA নাম্বারটা চেঞ্জ হবে এই WPA নাম্বার ফার্স্ট পেজে WPA নাম্বার
I'm confused.
Hello, report copy of our hand.
কপি অফ রিপোর্ট
I have already handed.
And previous one.
I cannot.
Previous one report has not handed over.
give both
State.
give both the report
Yes, yes.
you'll get it give
1358, 1358 a report.
135.
1359 a report. 1358, it 58. 58 এটা। দেবপ্রিয়া ঘোষ কুন্ডু। সোনামণি ঘোষ কুন্ডু রিপোর্ট।
59.
In connection 691, previous. Today's two writ petition, one is 1358 and 1359. I have served 1358, but not 1359.
আচ্ছা you take it let the matter
Yes,
be
ma'am.
called down কল করুন
1358. এটা দিয়ে দেন, 59.
On matters pertain to fair price of dealership. On the last occasion, your lordship will adjourn the matter as because the petitioner is apprised your lordship, my lord, whether
he will take he is not appearing
did not appear.
order record করুন none appears on behalf of
My senior is appearing.
31.
Oh, sorry.
My lord, at the cost of getting severely admonished, my lord, may I mention item number 111, my lord. It's a extremely urgent, my lord, matter, my lord. Relates to illegal detention of Erika nuts by the GST department in spite of me paying the penalty specified by them, my lord.
not like this your other side is there and at 4:30
My lord,
here
I'm sorry, my lord. I did not know, my lord, the matters are being called, my lord. I'll wait, my lord. I'll wait.
My lord, item number 32.
Upgradation. Upgradation.
Lordship,
May I mention
My
one thing?
lordship, may
Item number 128, can it be fixed tomorrow at 2 p.m.?
No upgradation. Don't mention for upgradation. Don't embarrass the
my
court.
lordship,
because-
My
my
lord, my
lordship,
lord,
may
my
I
lord,
to mention
kindly, my
any
lord, consider item number 100, number
No,
11, my
please
lord.
don't embarrass the court by mentioning for upgradation because if I permit one, I have to permit all. And upgrading all matters is impossibility.
Lordship,
May
Lordship,
indicate
item number-
only this, my lord. May I indicate only
Please,
this, my lord.
please don't repeat it. If I have said no, it means no. Merely
My
because
lord.
you repeat 12 times.
My
it
lordship,
becomes yes.
my lordship,
Yes,
one
madam.
matter, my lordship, item number, my lordship, 68 in today's list, my lordship, this matter is listing since Monday, my lordship. Today I present in court, my lordship. My lordship, my home is Alipurduar. My lordship, can this matter is very urgent, my lordship. This is illegal
What is
electricity
the matter?
distribution.
What is the matter?
My lordship, the matter is repetition. It is about illegal disconnection of electricity supply from my father's industry, my lordship. This is which is the only source of income, and this matter is pending since more than one year, 1.5 years past, my lordship. Due to
You
this
bring your
matter,
other
my
side. You bring your other side and then mention because merely on your mentioning I cannot take it. You give notice to the other side because she should be put on notice. Suddenly I bring it on top.
my lordship, I serve notice, my lordship. My
Serve
lordship,
notice
kindly
and
this
mention that
can
is-
be tomorrow, my lordship.
may I mention, my lords, item 39, my lords?